sides, and other sounds, please refrain from those. Okay? So that it does not
Court session, you may be seated. Good afternoon, Your Honor. February 27th, 2026, 2 p.m. call of the list. Call versus Kelsey Fitzsimmons, 2025, 77 CR 311. The Honorable Justice Jeff Carr presiding. Could counsel please identify themselves for the record?
Good afternoon, James.
Hello, Your Honor. Timothy Bradle on behalf of Kelsey Fitzsimmons.
Good afternoon.
Good to see you, Your Honor.
Good afternoon, Your Honor. Martha Coakley, also for the defendant Kelsey Fitzsimmons.
Good afternoon. Good afternoon.
Good afternoon.
You folks can have a seat.
Thank you.
All right, so we're on for a scheduling conference, and a couple things. Okay. I just want to make sure that folks in the audience and also the phone line is open. Yeah. Okay. That folks in the audience and on the phone line just understand that there should be no recording, video or audio images other than our media, registered media participants. Things. Now, if I have it correct, there's the final trial conference on March 12, 9:30. Is that right? Yep. And the trial is scheduled for March 23rd. Do you want Russell, how long?
Well, I haven't received any witness letters or anything like that. That's
Okay. So let me.
I agree with that.
Okay. Let me do this. Let me tell you what I have on the agenda, and then you folks can. It's pretty straightforward, and then you folks can tell me what else we need to go over. So we have a schedule set. We'll have to decide whether there needs to be any other interim hearings. I wanted to talk about deadlines for the very thing, trial motions, witness lists, what proposed voir dire questions, etc. And wanted to get a sense of just kind of an overview, very brief summary if there's any anticipated significant legal or evidentiary issues that you folks anticipate that may dovetail with our schedule as well. And so whether there's any discovery related issues, I know there's a motion filed by each side that's discovery related, if I remember correctly, to address those. And also something to get out ahead of time, to get out in front of that we can discuss as part of our deadlines, and that is whether there should be some kind of media related or spectator related order, just so there's some procedure in place for any expected issues related to that. And that's my agenda. I don't know if you folks had other things that you were anticipating or wanted to raise. No, that was anything.
no, I think you covered it.
I do have a few things.
Sure.
So we have a long list of things that we consider to be outstanding discovery. So I think we have a Rule 14 issue, and counsel and I have been going back and forth on it, but I don't think that there's been enough digging, frankly, about some of the stuff we're looking for.
All right, so I'll tell you what, that will be part of our discovery agenda. Okay. All right, we'll do that. I'm not cutting you off.
No, I
trying
appreciate it.
Trying to get an idea of what lays ahead. But yes, I do want to get out in front of the anticipated discovery issues, including the motions.
Sure. And Judge, on that bail motion, I certainly want to give the Commonwealth time to look at it and react, etc. The bail motion that I requested.
I saw something. I have not read it. I don't know if Mr. Kutosi shared. I had a charge conference this morning with a trial that's been recorded for 5 weeks. On Monday, and I just haven't had time.
Sure, I
so
understand.
if there was something filed this morning, I didn't see it.
Sure.
We can talk about that. You said it's bill related.
It is, Judge. It just, whenever you're ready to address it, but there's just some pressing aspects of her terms of release that are really hindering our trial prep.
Well, I think, so I have, I'll tell you this, I have read those, the materials that are in the file. I don't know anything else about the case other than what's in the file. But my memory is that, wasn't there a 58 order?
Yes, Your Honor.
And, so if there's any changes that need to be made to that order, I believe the law requires that you go before the judge that imposes the conditions. Is the defendant out on conditions of release?
She is, Your Honor. That's correct.
So, yeah, I mean,
So that's going to trigger a recusal hearing, Your Honor. We have a request for an evidentiary hearing that Judge Ricciuti, the Chief Justice of the Superior Court, took over, and he ruled that my motion to recuse the prior judge was moot because she was not going to, essentially, because she was not going to be around in the session. So this is a.
let me first get to this that you're talking about.
Sure.
So this is paper 54, defendant's reviewed motion for bail determination under section 57, 87, 276. So, when you say.
So we're asking for a revised bail determination. That's correct, Your Honor.
Okay.
And,
In other words, a change in the conditions of release or something?
yes, that's correct. The document 51 in the docket, Your Honor, is our just filed. The prior substantive motion we filed was a motion to recuse Judge McCarthy-Nyman from the case.
So let me first see if there's even an issue. So
Sure.
Presumably have seen this motion.
Yes, I got it. This one.
Leaving aside whether today is the appropriate time for it to be heard or not, what is the Commonwealth's position? Should it be heard by Judge McCarthy?
Well, yes. At the end of the day, there was a number of hearings in front of Judge McCarthy. The defendant appealed her decision to the SJC. The SJC denied the appeal, saying she did not use her discretion. That's where it stands now. Defense counsel did file a motion to recuse Judge McCarthy. As counsel said, the judge,
Ricciuti.
yes, deemed it moot because he asked her to get off the case, not anything else, just to get off the case. That's what the counsel was asking for. Because she wasn't in the trial session, she wasn't in the trial session, so none of that was acted upon. And so, but there's been an extensive history that the judge has dealt with. And frankly, I don't see a change in circumstances.
Well, yeah.
I would point to document 51 for a change in circumstances, Your Honor, about the true nature of what's been going on in this case.
Okay. So let me say this. I like to have practical results that be pragmatic as pragmatic as the rules of the law allow me to. So I don't. Is it something that you would object to me hearing or something? If I have the legal authority, if you folks agree that I have the legal authority to weigh in on it, I don't know that they would be the appropriate day to do it or not, but we can talk about that.
I appreciate you being open to that, Judge, and I can narrow it, in terms of what I want to impose a little bit on the court and on counsel today to deal with is, some of these terms are duplicative and they're just bureaucratic. They're just onerous. And, 48 hours notice to make an appointment to come to my office. I don't know when I'm going to be in my office within 48 hours, and I need to have Ms. Fitzsimmons more when I need her to prep. And so the idea of giving 48 hours notice to probation, to leave house arrest, to come to my office in Boston, is just extremely onerous. Also, she's in the custody. Oh, sorry.
So, because there's a couple different issues. One is whether, because I don't want to waste your time in the sense that it's something that doesn't need to go to Judge McCarthy. So, I guess what is the Commonwealth's position? Presumably, the defense position is that I can hear.
Yes.
And I should hear.
You should, well, our position is that she should be recused. We're more than willing, ready, willing, able, and happy to have an evidentiary hearing on it. I don't think the Superior Court wants that on her recusal. And we think that the entire framework of this case has been an absolute circus from the beginning. And I'm glad you're here, frankly. And I have a pending motion to recuse, not pending, but I filed a motion to recuse, Judge. And I am very unhappy with the way this thing has unfolded since arraignment. And we have moved to recuse. Judge Ricciuti, I think wisely, has made it a non-issue. And I want to forge ahead with Your Honor. And I want to go ahead with the case on all aspects with Your Honor. And I don't think it's in the Superior Court's best interest. I don't think it's in Kelsey's best interest. I don't think it's in anybody's best interest to kick this back to where it just came out of. And I just want to ask for a few things today. And I know that, you know, the court can say no, you got to wait. The Commonwealth can say no, you got to wait. But I think these things are not unreasonable. I just want to get rid of the 48-hour notice. I want her to be able to come to my office, get in a car and drive there on her own, like a grown-up. Her mom is the custodian of Miss Fitzsimmons. Her mom works full-time. This has been an incredible hardship on her. She's got to drive her to my office and sit around for 3 hours. It's really unfair.
Let's do this. Before we end today, we will address
Thank you.
whether I will address it or not. And the reason why is because I like to read it. When attorneys take the time, either side, take the time to write something and file it, I like to read it. And I haven't read it, and
I appreciate it, Your Honor.
completely at a loss without knowing. So we'll need probation up here if we get to that point. But we'll circle back. I don't want to start on something that let's just start looking forward.
I love the idea, Your Honor.
We'll do that. So, all right. So let's talk about legal and evidentiary issues, and just in the sense of deadlines. But what I would like is a joint witness list, and you know what, actually, I'd like a joint witness list because what I intend to do is treat this case like any other criminal case I decide over, and that is there will be individual voir dire, there will be attorney conducted voir dire, and there will be a questionnaire. That's kind of my standard procedure. Private case in front of you that I know your staff has.
I have.
Oh, you have? Yeah. Oh.
I guess
You
I'm
must have
not
done
that
such a good
memorable.
job that I don't remember. But in any event, so that's where we're going. So the reason why I bring that up is because one of the questions that will be on that case-specific juror questionnaire will be, do you know any of these potential witnesses? And what I like to do is just attach some Word document or something that has both of your witnesses on, both sides witnesses on there. Also, on there, we should list, the way it will be phrased is it will be potential witnesses and anyone possibly associated with the case. So if there's names of folks that their names may be prominent during the trial, some business may be prominent, I have no idea. Things of that nature should be just the mechanism to do that, put them on this potential witnesses so that folks can flag it in their answer to the question here. So that's and then also, frankly, I need to see a witness assuming the information that I don't have in confidence as well. And while I'm thinking of it, I will say this: it's not a conflict in my view, but I won't raise. I did see in the file. I thought before the doctor's eyes out. Is that on the defense side?
Yes, Your Honor, we have him.
The name didn't sound familiar.
No, okay. So I don't know if he's going to be a trial witness or not, but but I will tell you folks, I may know this, I used him a lot. I've been on the bench 8.5 years, and I don't know if he's testified before me. I did keep in touch with him professionally for the first year or two I was on the bench, just because I still had cases. There were still cases pending that I had been counsel on, so I don't think I've spoken to him in 7 years or something, but I did want to disclose that. Again, I don't see conflict at all, but you folks can think about it. Do you expect that he'd be with us?
So Judge, we're sort of on the fence about it, actually. That's the number one area that we're on the fence about. But if you don't have a problem with it, we certainly don't have a problem with it.
Yeah, I don't, but folks will let me know. So on the legal evidence, what motions, what unusual file motions should I expect?
I don't think there are really any unusual ones, bad motions, things like that.
Yeah.
Nothing unusual from the Commonwealth side. With the caveat that I don't know who their witnesses are or whether they're calling it an expert. And that's one of the things I think we need to address today.
That is a good point. So, because if there's going to be a mental health defense, so I want to keep this case on target from March 23rd because.
Agreed.
From my perspective, and I'm sure everyone agrees, if it's not March 23, then that's to the extent that the case is assigned to me, I don't know if that's formally done or not done. Then I'll be off to a civil session for 2 months, and we'll be waiting. So we've cleared the deck, so to speak, for March 23. So I'd like to make sure that we're on target to do that. But things like mental health defense could slow things up if the Commonwealth wants to hire their own expert, et cetera.
I understand, Your Honor. So I think the Commonwealth has Rule 14 problems, though. They've got to comply under Rule 14 before we have to do anything. And I have a list of, and I know the Commonwealth's been trying to kind of work with me, without bothering the court, which is always the best way to go on these things. And we're sort of getting there, but it's going very slow. And I have a list of about 8 things here that make their certificate of final discovery compliance really not accurate. So
can I ask, Mr. from your perspective, is it the Commonwealth's position that you folks have complied, or is there still outstanding discovery issue?
I think the only outstanding discovery issue, and I did reply to the defendant's request for his 8 items the other day. I hope he got my reply. It is the ones that we're going to talk about this afternoon. So, other than that, there's maybe an issue with I provide him with a link or something. But other than that.
Well, I'll tell you what. We'll put it on the agenda. Let's get right to it. What
Sure.
are the discovery issues?
So Judge, today,
And could you say that there was a certificate of final possession?
the last date, Judge, right? And
Okay, go ahead, Mr. Gray.
thank you, Your Honor. So Judge, today, the Commonwealth is giving me a surveillance system that was taken out of the house. So I appreciate that. We've been looking for that. There's some video. So there was the actual, they took the actual system, right? And we need it for some other cases as well. And we've gotten that taken care of today. The Commonwealth's going to give me that system today. Expert notice. Okay, so under Rule 14, I don't think we have the proper expert notice in terms of the CV and who's testifying as an expert and what's the opinion going to be. I don't know that I have everything on that. And I'll elaborate on that a little bit as well.
Yeah,
Also,
well, let's just take them one at a time.
Sure.
So, what kind of experts would there be unless there was a mental health defense? You talked about ballistics?
Yes, it's ballistics.
Right.
I turned over the CV to defense counsel on that. He has the report of the ballistician, who analyzed 3 guns and says that 1 gun matches the shell casings that were found on the scene. Other than that, I don't see any other.
But this isn't, the defendant's not charged with a firearm offense, right? It's AEW.
So here's where I'm going with this, Judge. We're sort of talking about 2 separate things. The Commonwealth has given us a 7-page report, and the report concerns the guns that the responding officers have. It lists 3 Glocks, and they're all their service weapons of the responding officers. So that's great. I'm not interested. It
No,
doesn't.
that's incorrect. And then I sent an email to him February 6th, because we had talked about this. I hate to interrupt, but it's just wasting time tonight.
Yeah, go ahead. I'd like to hear it. Go ahead.
And in the email, I talked about which gun was which gun. There was 2 officers who were on the scene, one shooter, one officer Newman who discharged his firearm, another officer who did not discharge his firearm, and the gun that the defendant is alleged to have. Yes, who was alleged to have. And that was her service weapon. And I detailed for that. And so the analysis that was done on the gun that was involved in the shooting. And so that's all.
So this would have been, what was the officer?
Newman.
This would have been officer Newman's service weapon.
Yes, and so I had sent an email because we had been talking about that on February 6th concerning that exact issue. To clarify.
So I appreciate counsel interjecting with that. And if it's, I'll go back and look at it, but I read it to be the 3 officers that were at the scene and that their guns were taken pursuant to protocol. But if the Commonwealth is saying that that's the gun that was used, then that's fine. And I'm satisfied with that. I didn't read it that way, but if that's how the Commonwealth has it, I'll go back and look at it, and that's fine. So that's we can take that one off the list. Body worn cameras, Your Honor. There were an officer visited Ms. Fitzsimmons early on when she was at Mass General Hospital. She spent 53 days at Mass General. An officer visited her there. And I don't know if there's a report that emanated from that or a body camera that emanated from that. And then,
So when you see body camera footage, it's very narrow, you're saying? Like
Right.
It's a specific event.
right, it was one officer that visited her at the hospital, right?
Okay, and was this a social visit or something?
That's a good question. It might have been half and half. I'm not sure.
And, would this have been, a North Andover officer?
Yes.
State police?
Yes.
So, and have you told the Commonwealth the identity of the officer?
It actually might be a trooper. If I could just have one moment. Detective Dan Furman.
I don't use that.
So he visited Ms. Fitzsimmons at the hospital, and if there's any,
I'm sorry, I meant when I said use that, I meant, what you say.
so there's a visit from someone who's might be a social visit or a police visit. I don't know what it is, but I'd like to know if there's any documentation of it.
Right, so this,
And body
but again, this person's name is
Furman, F-U-H-R-M-A.
Okay, and what police agency does he work for?
North Andover.
Alright. So this should be, well, you're saying that you don't know if it was a social business or not?
All I know is a North Andover police officer visited her, and is there any documentation of it, or is there a report? Is there a text message from it? Is there anything from it? I just want to know.
I'm not expecting any answers right now, I'm just, you want to weigh in on this?
No, that's the first I've heard of it. And I think the defendant would know if it was a social visit or anything like that. I don't believe North Andover has body worn cameras, but I will certainly make an inquiry. It's the first I've heard of that.
And then there's also a body worn camera from Ms. Fitzsimmons' arrest at the hospital. She was arrested at the hospital and kind of cuffed to the bed, and pursuant to the district attorney's office wanting to move the case along and get her arraigned. And there should be body camera from the state police from that.
So is it?
And I believe that's Trooper Strong.
Is this request, are you familiar with this?
My understanding that Defense Counsel called me and asked that there not be body worn camera when the state police run the car. So I would double check that. So.
My client tells me that there was body worn camera that was activated, and that she was informed that there was body worn camera.
There was, it sounds like it wouldn't have been or in.
No, that's
The state police, yes, Trooper Strong.
Is here today. I'll ask.
Right, and you know what, actually, because the troopers here, to the extent that we can put any of these issues to bed today, that would be great. So what else?
Promises, rewards, inducements, Your Honor. That's the subject of an entire filing today.
So we will, you want to do that now, or you want to, what else is on your list? So,
That's the list, Your Honor.
okay. All right, but I want to make sure I'm not missing anything. Can you say that you had 8 things and I only have 4?
So I'd like a witness list from the Commonwealth. I'd like to move to strike the certificate of discovery compliance to the extent that it triggers our obligations when their discovery obligations are not satisfied.
By the way, I don't have these rules about, I have a case in front of me now where there's 3 DAs and 3 assistant DAs and 1 defense attorney. They're all welcome to speak, so to the extent that I don't have rules against more than 1 attorney speaking.
I appreciate that, Your Honor. I'm not afraid to speak. And Attorney Gradle knows that. No.
I don't want anyone to think that, to the extent that you want to be heard, you can be heard.
Thank you. I appreciate that.
What else?
Judge, there's also some OneDrive links that I know that counsel refers to. There's some OneDrive links for some discovery that we don't have. That we got some Axon discovery that had OneDrive links in it, and it was not communicating very well with our computer. So counsel is going to get me OneDrive links for, I believe, I guess I won't. So I'm actually at a loss to say what's on these OneDrive links because I can't open them.
Yeah, but as I said a few minutes ago, I understand what you're saying, but I understand the on Monday.
All right, what else?
I believe there were some redactions in the grand jury minutes that were given, Your Honor. And if there are any redacted grand jury minutes, we need the unredacted grand jury minutes. Right, I didn't, yeah, it was strange.
No, and I tried to explain this. When you got a redacted exhibit that I used in grand jury. And it was an interview with some of the officers that talked about things that I thought were too prejudicial to the defendant. And so I submitted to the grand jury for their consideration the redacted exhibits. Okay. However, he has the full exhibit also, meaning a full unredacted version of those recordings. Okay. So the grand jury minutes themselves, I'm sorry to interrupt. I'm not redacted.
Okay, that's, if I have it, I'd like to have it. You know.
So yeah, I mean, it sounds as though Mr. Vigorous is produced and will not both the redacted and the unredacted versions, and you'll have a record of what exactly the managers you know already.
Thank you.
What else?
The rest is the promises, rewards, inducements motion. There's 2 key witnesses here that are.
We're ready to.
Yes.
So,
Yes.
So, let me just do that up. So it's paper, it's been documented as paper 53, defendant's motion for disclosure of promises and words of inducements. And I have read it, I've read the attachments, and I don't know if this is an issue for Mr. Kelsey or not, so I'll say that the problem that I saw with the motion is that it's not supported by affidavit. And I don't know, again, if that's something that the Commonwealth would raises or not, but to the extent that you're relying on statements of your client and your client's father, I typically would see that in an affidavit form. Is that it?
Well, Judge, I do have an attorney's affidavit, and I do at the end of the motion, but I do view it more as like what we're doing here from the defense side is we're pointing the Commonwealth to specific exculpatory evidence.
Right.
So, you know, whether how far we have to go with affirmative, you know, averments of that, you know, I don't think it's not like a motion to suppress where we're asking for the court to, you know, make significant rulings. This is a notice to the government that says, hey, look at all this stuff that has happened, and you know, you need to figure this out. And I think that the government in this case, with respect to this Alain guy, has rose-colored glasses on where they're like, you know, they don't want this guy to be harmed. They think this is a probate court issue. They think this is, oh, just, you know, just focus on Kelsey. Let's not worry about this guy. Don't look over here. Don't look behind the curtain. So this is an incredibly egregious thing this guy did. Miss Fitzsimmons was in the hospital fighting for her life. That was her home. He had gone and gotten a restraining order in which he swore in the affidavit, I don't live there. I live in Stowe with my parents. He's now a plaintiff against Miss Fitzsimmons as a defendant in the restraining order matter. He has no rights to that house whatsoever. 3 days later, her dad, who's a security expert and owns a security business, changed the locks, updated the security system, made his daughter's home secure again after this thing happened to her. And after the shooting, and she's in the hospital, she's away from her house. And this guy takes advantage of that to commit all sorts of serious crimes. He's on video breaking into the place with 3 other friends, 3 other accomplices, bust down the door, come in, it's on video, it's in an exhibit that you have, and he commits all sorts of serious crimes. The most serious one for purposes of this case is that he stole evidence. He stole evidence off the refrigerator. It's a felony. He had just.
Can I ask you something?
Yes.
Assuming everything that you say is true, the motion is for promises, inducements, or rewards. So your theory is what, that the Commonwealth promised to not charge this guy or something?
Yes, that's exactly what we think. And he's a perceived witness. He's at the scene of the shooting. He's at the scene of the shooting. This isn't about, 3 days earlier he did this order. It's that he's a recipient witness at the shooting. He's there. He and his sister are there.
At the end of the day, the motion is for promises, inducements, and rewards.
Yes.
As those terms are understood, is the Commonwealth made any of those or offered any of that to this gentleman?
I think I can answer it this way. As far as him being a recipient witness, and you don't know very little about the case, the 2 people who were there in the room when the shooting occurred, when the allegations against the defendant pointing the gun at Officer Noonan and pulling the trigger, and him shooting her in self-defense, the 2 of them were. That's in the top floor of the bedroom. Mr. Arielian was in the basement at the time of the house. He's on surveillance video in the basement. He hears it. So he's not a recipient witness. I'd just like to put this up. But the case does not rise and fall on him. he might be a background witness, he heard the shots, but as far as what happened in the bedroom, he has no idea. So to say he's a critical recipient witness, I would suggest. Now,
Whether he's
no, and that-
or not, there's either.
And I agree. And, but I just have to correct the record.
Sure.
Now, defense counsel sent my office a packet of information, including, and we have the video of, oh no, we didn't have the video. We sent the video of Mr. I'm going to call him Justin. I apologize. I'm having trouble with his name. Entering the house on a specific day. And the Commonwealth, and what is omitted from the defendant's argument, and he has this, and he knows that the day before this happened, Justin called the North Andover police and asked if he could enter the apartment. He told them that the defendant was on the deed, but he had property there. And they told him he could go in. On the next day, where this video is, he calls again and says, I need to go into the apartment to get my stuff. He asked for a police escort because he's afraid of what the defendant and the defendant's family would do if he went in there. He was worried about his in his words, vengeance. Okay? And so he does go in. He does push the door open. He goes in to retrieve his items. No, the police didn't come. At that point, the alarm went off because I'm assuming there was some surveillance video in there and an alarm system. When the alarm goes off, he calls the police and he says, can you come here, please? The alarm went off. I'm worried that the family of the defendant will come, and I'm worried what will happen because they're very vengeful about the whole situation. And they said, we're not coming, but if he shows up, let us know and we'll come and keep him. He then gathers his belongings and left. So we can't look at a crime, the Commonwealth, in any case, it's not looking at a crime in isolation. We have to make determinations when we're looking at cases. Justin, has also filed an affidavit in court. No, probate court, as the restraint, which 3 judges have been found present. And the defendant has yet to litigate that. And so we have information from the defense about what happened, about this breaking and entering and this supposed theft of evidence, and that's the first I heard of it. And we had that passed. We reviewed it in an abundance of caution. We asked Middlesex to look at it, and they were going to take a look at it. At that point, Attorney Coakley called Middlesex, the first assistant, about that. Middlesex then called us and said, we can't do it. We don't want to take a look at it. We think we have a conflict now. So our office then looked at it, and we determined that we are not going to charge Mr. Dillon for these crimes. I don't know if he even knows that this is out there. I don't know if he even understands that there are charges that the defendant is alleging occurred. I haven't talked to him about that. If I do, and if he has a concern, I'll tell him that we're not charging him with that, based on the entire circumstances of this case. The Commonwealth is often in the position of analyzing cases when there are dueling issues, dueling statements. And we have an obligation to parse those out. And if we don't believe there's probable cause, we don't charge. That's what we have here. The Commonwealth has made the determination, not in isolation, but in the whole circumstances of this case, that we are not going to charge him. If at some point during the case, Your Honor thinks he has a fifth, we'll immunize him. But we haven't told him that. Defense counsel is now on notice that that is our position. So is it a promise of word inducement? It is what it is right now. So they're on notice of that.
So, Mr. Graham.
Yes.
let me see this. So the whole idea of the discovery, obviously, disclosure. It sounds like perhaps this is the first time you've heard the full version from the Commonwealth's perspective, but to the extent, now probably isn't the time to determine whether it's a notice of inducement or reward. I think now is the time to determine the sufficiency of, assuming that it is one of those two things, the sufficiency of the notice provided.
Absolutely, that's what we're interested in, Judge.
All right, so.
Communications, right.
So it sounds as though, so what is it further that you're looking for? You want something in writing that they're not?
So just a couple quick things, Judge, as far as what almost said. I have the call that he made to North Andover, to one of the sergeants up there, I believe Sergeant Berkey, I may not be saying her name right, but we have the call. And in the call, he's committing another felony called misleading police. He's saying to her that he still lives there and that he wants to get in there, and he's looking for a dispensation from them to let him get in there. And he lies to her, and he says that he still lives there. Completely contradicts what he already swore to the probate court judge, family court judge, to get the restraining order. And so the sergeant, I think, does the right thing and says, well, if you have a key, or, if that's your house, I can't stop you from going in your house. But she doesn't say, yeah, you go right ahead and go in the house. She's deflecting and saying, well, you're telling me you live there, I can't do anything about it. So it's this sort of round and round conversation where he's trying to get dispensation from them. And she wisely just says, well, if it's your house, go ahead, but I don't have anything to do with it. That to me is the gist of the conversation that I have. So there's yet another crime that they're looking the other way on for this guy. But in any event, so I'm sorry, because I'll tell you what I'm looking for, okay? All right, I'm sorry. So I'm looking for text messages, emails, notes to, what is the police, what is the DA's office, what are they saying about this incident that they know about? Are they saying, don't worry about it, we're not going to prosecute you? I want the communications. What are they saying? I can't, it's always hard from a defense perspective to, guess what's out there. They should be giving me, here's all the communications about Elaine and him breaking into the house and why we're not prosecuting him. And this whole business about that, he checked with the police, he lied to the police. So he didn't check with the police. So their facts are all wrong. And, he should be prosecuted, and they're in a conflict of interest, and the court should direct them to appoint a special prosecutor because they clearly have a conflict of interest in trying to prop this guy up for their own case. And so they ought to be ordered by the court as a matter of ethics, as a matter of appropriate behavior as an attorney to appoint a special prosecutor. And I want to ask the court to take a serious look at that.
Can you, and Ms. Fitzsimmons as well, come on over to the sidebar for a moment.
Okay, I had to come on because I'm writing this stuff down, and Bradel is on fire, and he's absolutely right. The judge is just trying to avoid this. Can you imagine? This is the issue. Two things. One, the Commonwealth is arguing that the baby daddy, it may not be a precipient witness, which tells me they don't want to call him. But secondly, that they had decided not to charge him. So Bradel said, I want to know why you decided not to charge him. He said, well, because and this is the first time we're hearing this, the first time Bradel's hearing this also. We decided that there wasn't probable cause, but there is probable cause, and who knows what they had about the computer. You just can't go to somebody's computer, steal it, and do all this other stuff. So why did they not try to charge him is my question. On what? On just breaking and entering, or stealing the items, or searching the computer? I mean, I think Bradel's has to go there next. He's got to really go at it. He is really trying his best, but it's clear the judge doesn't want to doesn't want to deal with this. Let's just go back to where this started. It does look like the judge is going to do something with the bail with Kelsey, so she can work with getting her case prepped for trial. So there's no delay for the Judge Karp because he said he will deal with that at the end of the hearing. But first he said you had to go back to Judge McCarthy Naaman to get your bail conditions changed because she's the one who set the bail conditions. And Bradel said, well, we're going to have a motion to recuse. We had a motion, but the court said it was moot because she's not going to be on the case. And we want you, Judge Karp, to stay on the case, but you can't send us back to there. So we're going to have to file a motion to recuse her from hearing the bail, which you're going to have to hear, or she's going to have to hear first, okay? In that regard. But he did say something to the end, well, I'll deal with the fact that she hasn't been able to work with you. And the reason what the bail motion, the end of the bail motion, I don't know if you can see this, the end of the bail motion, this is the last page, this is all that really counts. It says, continued GPS monitoring with exclusion zones of Stowe, Massachusetts and North Andover, allowing Ms. Fitzsimmons to leave home to meet with her legal team at her own will without 48 hours notice, to live in her own residence, to maintain mental health counseling sessions with documentation of attendance to probation, maintain stay-away orders, and the foregoing proposals will maintain a proper balance between the court's need to supervise the defendant with the defendant's presumption of innocence, liberty, interests, health concerns, demonstrated history of nonviolence, and a lack of criminal record. So that's what they're asking for. They're basically asking that she get to live alone with the appropriate mental health counseling and leave her own residence to meet with her attorneys in these areas without the 48 hours notice that's now being provided. So that's really what the bail motion is about. So it very well may be that the court may allow her to leave to meet the attorney on just mere notification to the probation officer or something like that. All right. But with regard to the other bail requirements, I think he's going to make Bradel file the motion to recuse that he had filed before, which the courts basically said were moot because Judge McCarthy named and was off the case. But apparently, if you have to go back for a bail motion, she's not off the case. That's where this case started. That's where this started today. There's a lot of other things that happened. Right now, they went to the sidebar. I think the judge has got a little more than he can handle here because he clearly doesn't want to deal with this motion as Bradel has phrased it, the motion for I want all discovery regarding promises and inducements, right? Promises, rewards, and inducements. That's what we spent the whole show on last night. You can go look up our whole show. I have it hashtagged in Twitter or pushed in Twitter. And then the judge says something about my problem is that this is not supported by affidavit. What do you mean it's not supported by affidavit? This is where Bradel was very smart here. He filed this not as some kind of dismissal. He filed this as a Rule 14 violation, basically saying, hey, Commonwealth, you said you were ready for trial and you've given us all discovery, but you haven't given us all discovery. And our discovery obligations as defense aren't triggered until you have completed your discovery obligations. So I think the judge has to back down on that a little bit, and that's why he's now getting into this. I mean, there's other things that happen, but this is the most important, and that led the Commonwealth to say that baby daddy, or as Michel Bryant would say, the alien, is not a precipient witness, which tells me they're trying to look for a way not to call him, just to say, this happened, and I think they actually could try their case. By the way, I'm just telling you, without actually calling him. And then you don't get into the issue of whether you have to grant him his Fifth Amendment rights that we talked about last night, all right? Because right now, I think he has to be given his Fifth Amendment rights. I think even if they talk to him, he has to be given his Fifth Amendment rights. But then we learn for the first time that we do, as we discussed in the past, sometimes you file a motion not because it's going to be granted, but because of what you get in information in filing the motion. And we just got some information. The prosecutor is saying that, well, there was a decision made in that office. Yeah, they're at sidebar. They went to sidebar. There was a decision made in that office not to charge him criminally, but not charge him criminally with what? The breaking and entering, because they felt that Kelsey somehow he had permission because he called the police and checked with the police. Well, the police can't give him permission to go into a house that belongs to somebody else and break that door down. They can't do that. It wasn't his house. So I don't know where the prosecution is coming from with that. Imagine if this were like a young black male off the street and he broke into that house, but called the police first and said, that house looks to be empty. Do you think I can go in there and check it out? Oh, come on. What are we talking about? The judge is trying to avoid this issue, in my opinion, clearly trying to avoid this issue. And then there's other crimes here. There's a lot of crimes we discussed. It's not just breaking and entering. It's destruction of the property inside the house. It's taking of the computer. It's taking of evidence. And Bradel made a big portion of this. It's taking evidence, all right? It's taking exculpatory evidence, but it's tampering with evidence, okay? And then you have the computer that's being taken. And we saw that there's some indication that the computer was gone into, that not only the computer was gone into, but accounts were changed and money were taken from accounts. The prosecution hasn't mentioned that. And then there was a HIPAA violation, and there's HIPAA forms. If we had to list all these crimes, I could go down and list all these possible crimes, all right? And I don't think the prosecution was doing that. I think they looked at the fact of, did they let baby daddy in the house because it had been his house, and therefore they said, well, maybe she didn't give him explicit permission to be in the house, but she didn't say no, she didn't say yes, she just didn't say no, she just didn't say anything. Yeah, because she was shot in the goddamn chest, okay? I was going to use another word, but this is a family show, isn't it? Okay. She was shot in the chest. Yes, I was thinking the same thing. Kelsey can file a criminal complaint, then she has to testify on it. But look at, you want to take look at my client, Aiden Carney in New Jersey, being subject to a citizen's complaint. Citizens can file complaints, okay? All right. It seems to me that that's getting more attention from the Commonwealth, his case, even in Massachusetts, than this is getting. You really have clear evidence, in my opinion. Now, the Commonwealth obviously doesn't agree that crimes are be committed here, or certainly there should be an investigation, or as Tim Bradel says, and I know I'm talking fast because I'm trying to get it all in before they come back from that sidebar, that there should be an independent authority that investigates this, because the Commonwealth, in finding that there is no violation, has a conflict in and of itself, because they may be finding there's no violation because they want to preserve their case against Kelsey. And again, they're trying to get ways around it, whether it's not calling him, whether they're not charging him. And that's why they're trying to get ways around it. I think Bradel and Martha Coakley have to go to the AG's office. She has the juice. I think they have to go to the U.S. Attorney's office. And I think they have to do what I did in a case recently. I won't tell you which one, but I filed a notice with the judge that he may have to give a witness Fifth Amendment warnings, and just the judge to be aware that there may be Fifth Amendment warnings that the judge has to give if somebody gets on the stand. All right, and I didn't expect a ruling on it. We never got there. But I think that's another thing that you could file here, that notice, because yeah, it may not be a crime because you don't want it to be a crime. But if you're the charging authority and it's in your best interest that the alien or the baby daddy not commit a crime, then of course you're going to say, we don't find PC, we don't find probable cause. But then Bradel says, but I want all that information. I want all the texts. I want all the notes. I want all the conferences you had within there. That's all discovery for me if you're not charging him. But then the Commonwealth is going to go back and say, well, it doesn't matter if he's not going to be a witness, you see? So I see what they're doing. I see what the Commonwealth is doing. I see what they're trying to do. They're trying to get out with calling him as a witness so they don't have to comply with this discovery. That's clearly what's going on here. Now, with regard to the sound, let me tell you, the channel, the legacy media channel that was there didn't have a microphone. Michel Bryant made him put a microphone on. Amanda's got a microphone because we told her which one to buy. Let's go back.
Find as a common word of use, he could better legal minds than I. And if the defense feels as though as it relates to that particular person's age,
Elaine.
As it pertains to Mr. Elaine, that the defense needs something further than that. Put it in a motion or a letter. I mean, it won't be a motion if you don't need to bring it to my attention.
I'm more.
And then, Judge, just to close the loop on that, so there's also the same issues relative to Officer Newman.
Right, which is the second part of your motion.
Yes.
So let's hear that.
All right, thank you, Your Honor. So, Judge, we're pointing the Commonwealth to more specific information relative to all sorts of special treatment that Newman is getting above and beyond, what is essentially in North Andover police policy. There's been misconduct that it may have been overlooked. We're asking for the discovery, so we should be in the position of saying, here's everything we exactly know 100%. We get all sorts of information. We investigate our case. And so we point to the Commonwealth and say, we're not getting the whole story here. We're getting all sorts of background information. We're pointing you to the North Andover police and what happened with this guy being AWOL and being forgiven. What happened with this guy and drug issues that may affect his ability to perceive and recollect the trials.
From a discovery perspective, we least from my perspective, is, it sounds like that's a little 17-ish, right? It
It's
sounds
the
like-
prosecution team. Sorry to talk over them. It's the prosecution.
It sounds to me that, without condoning or weighing in on it, just again, that the issues related to the way that the North Andover Police Department did or did not treat the officer that was involved isn't something that the Commonwealth. These are not members of the prosecution team that are, I presumably, that are making decisions related to the treatment of Officer Newman, which I assume is the subject of a collective bargaining agreement. Which I think may have even.
Yes.
I saw somewhere in the file.
Yes, sir.
So, again, to the extent, and I'll hear Mr. Kubatowski, to the extent that members of the prosecution team were involved in some decision related to his treatment, maybe arguably that would be discoverable. But I think that really what you're asking for, aren't you, is you're asking for personnel records. Aren't you? You're saying.
So, I think he's their primary witness. He works for the police department. He's engaging in certain conduct that looks like it's misconduct to us from the information that we have. And we don't have the entire bit of information, but they do. And
Yeah, I'm trying to just cut the chase here. Is any member of the prosecution team, as you know, it's defined, in possession, custody, or control of any of this information? Or is it your position that it's in some IAD file or personnel file?
If it is true, and the first I heard of this was when I received this yesterday morning, we don't have it. I think your analysis is correct. It's a personnel issue. If he wants to file a Rule 17 motion attaching an affidavit from a person who has firsthand knowledge of what is going on here, then I'd facilitate it.
So Mr. Prater, what I'm trying to articulate in a long day and a long week is that if you believe that there's some document or information that's in the prosecution team's as that term is defined, as we use it for discovery purposes, then if that's something that I can do something about. But at least from my reading of what you're alleging here, these are things that would be found in personnel files or perhaps other documents held by the North Andover Police Department. Again, if there's some computer system that keeps track of these things these things would be in.
so well, let me give you a scenario, Judge. Let's say he screws up. He's taking prescription drugs and he doesn't show up for his shift. I would assume that would generate a flurry of emails. Sorry, I screwed up. I won't do it again. Or don't worry, Noonan. You're all set. We need you strong for the Fitzsimmons trial. You know, they'd be in the custody of Noonan. It's a police email about a police witness. Like, no, it's not good enough for the government to say, oh, we don't have that, Judge. They have a duty, and they have a turbocharged duty under the new Rule 14 to go out and look and go out and inquire and say, what do you have on this? Bradel's saying that this guy is on drugs, doesn't show up for his shifts, doesn't get in trouble, has a collective bargaining waiver where he can go work details when he's out on leave, none of which is in the regulations. Where's this coming from?
As it's understood by the possibly be in possession of any of that information. Mr. Kubatowski represented that I assume that his office, the prosecution team, not the office, prosecution team is not in that, does not possess that. And to use your analysis, you that would mean that everything that officer, because there's a police officer that's involved in some arrest, that everything that that officer does in other cases related to his work at the police department is somehow discoverable. It may be discoverable, but the mechanism would be rule set. So I'm not, to the extent that you're requesting, to the extent that the motion, not even the motion as it relates to officer union and these promises, inducements or rewards, to be denied because these aren't promises, inducements or rewards in the discoverable sense of the district.
All right, I'll file a Rule 17 motion.
So,
Thank you.
yeah, and then as for, I'm not sure that you need a particular ruling on, well, let me ask you, on the first part of the motion, could I allow it? I don't even know what's your position, Mr.
As far as,
to the extent
well, no, I mean, the reports, I'm looking at page 7 of number 53.
yeah, let me address something that, to the extent that there's some motion for me to name a special prosecutor, I'm not aware of any authority that I would have to do that. There's something called separation of powers. So,
What about, if I may, Judge, what about conflict of interest? I mean, if the court has a conflict of interest before it, I think the court can say, here are the facts. I find that you have a conflict of interest. You need to either, set up some sort of a Chinese wall prosecution system or appoint a special prosecutor. And, I think that's a legal determination. Ultimately, it's a legal determination.
I'm not aware of any statutory common law or even constitution-based provision that would grant you the authority to order the common law to prosecute or to investigate something or not investigate something. It's classic separation of powers. So what the issues that are before me are, again, compliance with Rule 14 and defendant process rights, and just getting out in front of something that may trigger a trial motion.
Can I take one more crack at it, Your Honor? Thank you. I know you had a long day. Judge, I have in mind when I read, SJC decisions. Let's say a defense lawyer has a conflict of interest in his trial representing someone. I recall, in my aging brain that, the SJC says he had a conflict of interest relative to the defendant, new trial order. So the courts do say, lawyers have conflicts of interest and it has legal ramifications. And I don't see how that could be any different where the Commonwealth has a conflict. The courts should be able to order it.
It's the remedy that I'm raising the issue. Okay, it's not the issue of conflict of interest weighing in on that. It's that you're asking me to fashion a remedy that I don't have the authority to do.
Maybe the court could say a non-conflicted person. You need to put a non-conflicted person in this room.
I know of no authority that allows me to meddle into it. I can really do my own job. You want me to do the DA's job too?
I appreciate you hearing me out.
So it sounds as though the Commonwealth is going to comply with some of these requests as early as today. They made the disclosure on Mr. A. And ask for you to look into the second from the bottom camera and whatever else.
Yes.
It's in the Commonwealth's best interest to they decide because they want to get as quickly and assuredly as Ms. Fitzsimmons. So let's.
You guys have heard on one issue? Sure. And there's an issue that I sidebar that whether Rule 14 has been complied with or not. I'm asking that the court order disclosure of any expert witness that defense I don't think it is a big ask.
So Judge, I was just gonna pull up the rule, but I think that the legislature in passing the rules of criminal procedure set it up this way so that the Commonwealth has an incentive to give the defense discovery. They don't get the candy until they give us theirs. That's the rule. It's not, I don't think it's really something that, they can't have their cake and eat it too. Give us all of our discovery. It's a good incentive for the government to provide everything. This is routine in every case. I think of the Karen Reed case in Norfolk County, Judge. The government didn't comply with Rule 14 until like the day before trial. And Judge Cannoni held the line on their discovery compliance was not due until the government complied. It's just a rule. I don't think it's really something that should be messed with, honestly. It's there for a reason. The government needs to give the defense, who has a right to remain silent, who has a right to evaluate and do something or do nothing on the case. And we have a right to look at the evidence and then decide what we're going to do.
Right. So I think if I'm reading through the line, Mr. Grado, your position is that you have no notice requirements under the rule right now because the Commonwealth hasn't fully complied with the rule in the way of
correct.
And what I can tell you, Mr. Proceed, is that I don't think too highly of any trial, attempts by trial, by ambush, by either side, and I'm not going to let it happen. So if the position, again, both sides are going to comply with the letter of the rules, and so the answer is I'm not going to order it, but I'm also going to be conscious of making sure that the spirit behind the rules, which is again no trial by ambush, doesn't happen to either side. So
Thank you.
in other words, I can't foresee tell what's going to happen about. All the sides are going to do their best to get this case to trial on March 23. But it won't be at the expense of the defendant's due process rights or violations of the rules. It's just that simple. All right. So that leaves the motion for medical records.
And that is agreed to or not objected?
No objection. Agreed either way.
The only thing is I didn't have an order, so I told clerk that I could send on Monday.
All right, so you folks worked out the way that this is going to be handled in the sense of they're going to be summoned into the clerk's office and impounded.
I can't remember the last time I ever had a procedural objection to medical records. Judge, they get produced, I'm not going to object.
Yeah, they should be not available to the public, available to the council.
Oh, I'm sorry. Yes, yes, I appreciate that. Yes.
So all right, so this is the easiest thing. Allow us without objection.
If I could put a little asterisk on it, Judge, could the defense have eyes on it first, just to make sure there's no,
I can't.
And then if there was something objectionable in terms of discovery, not admissibility, but discovery, I would immediately bring it to the courts and council's
So you're
attention.
not going to make this thing.
I'm sorry. I'm sorry. And I'll come right up. As soon as they're here, I'll come right up and have a look.
So and then what happens is, so there's something, and you say that there may be something that you don't want to follow.
You can look in camera and make a rule.
Well, they're medical records. I mean, we're not asking for psychological records or anything. They're emergency room records.
I'm sure they're fine, but I'm just trying to be careful.
Well, if you're sure they're fine, then let's just handle them the standard way. Okay, and let me say this, that I'm going to order that to the extent that copies are made, that they're not disseminated, all right, and that they're not used, that you don't file them, they'll be impounded, and that will give you a chance, Mr. Brady, that you don't have to rush the race to
Thank
the Lawrence, because that's a race you're going to lose.
I appreciate it.
You're in the building. And then this way, again, there's not gonna be cat out of the bag, so to speak. It's an issue of whether they're gonna be able to be reused or disseminated.
Thank you.
And that won't be. So I'll take care of that. And, all right, so that means, let's talk about deadlines and then we'll talk about this field issue. So on the deadlines of, so was it your position that I can't order deadlines on trial motions because the combo hasn't applied?
No, Your Honor.
So, you folks want to keep the, March 9 date?
I think it got moved to the 12th, Your Honor.
March 12th date. You want to keep that?
Yes,
So
please.
what I'd like to do is have things filed so I can look at them ahead of time, and also so that they can be served at the same time and the other side can file any written oppositions. So let's say, how about the end of business on the 9th work?
Yes, thank you.
And then this will give you folks, a couple, you'll have time to propose, also, and then we'll hear those on the 12th. And so we're talking trial motions. I'd like to get, any proposed jury voir dire questions, whether they would be part of the questionnaire or part of the actual voir dire. To the extent that you have anything that's unusual or not, that would be terrific. What else? You know what else would be helpful is whether you had, I think I mentioned before, whether there's anything that should or should not be in a media spectator type of order. To the extent that we folks think that we need that as well. That would be helpful. And witness lists. So, frankly, I'd like to give you a witness list soon because again, if there's some conflict that we have to flesh out. So, Mr. Graylor, you need a minute or?
No, Judge, just
What I'd like
all set,
to
thank
do is get a list of prospective witnesses and or folks that should be mentioned somehow during voir dire. Let's say next week, by the 4th, right? And again, these are, can you do that?
Yes.
So you need more time? Is that all right?
Yes, Your Honor.
All right, and just make it over-inclusive. Okay, again, the idea here is twofold. One is to make sure, for me to make sure that there's no, that I don't have any conflicts case, but also so that we have something to be able to tell our prospective jurors. All right, it doesn't commit anyone from calling or not calling someone. Do that. Yeah. I don't need a statement of an agreed upon statement of the case because you folks will never agree on it, and it's just going to be for my purposes of what I tell the jury in front of the area, which is going to be some plain vanilla.
Well, I mean, frankly, the parents of Michel, but it's pretty great when I get on.
We can do it. We can do it, Your Honor. We'll give you some.
But again, as I told you folks inside my know professionally, and I was surprised that that wasn't the case and correct. So happy to hear that. All right. Did I miss anything on the deadlines?
Judge, on the 12th, is that a 2 o'clock call on the 12th or 9 o'clock? 9:30?
And again, with the idea of doing as much as we can on that day, get this thing lined up for 5. So it's going to be important that you folks flag if you have there's a trial motion where you think that there should be a voir dire of some witness or something. Flag that in the motion. Because again, I'm going to need the and I'm not suggesting you need to show up on the 12 witnesses. We'll have to have another day to do that. But these are things I'm going to need to know. So, what else? All right. And then, so that leaves us with, the purple elephant in the living room, and that is the bail issue. And so,
There's a few things, Judge, that the Commonwealth may not have too much of an issue with, that it's just really hindering me. And I don't think they're really the central issues that the Commonwealth is concerned about. So could I take a crack at it and just,
well, here's the thing, too. I also, without knowing the history here, I don't want to be stepping on another judge's toes in the sense of, I have no idea what, because traditionally, not even traditionally, as a matter of law, I've always understood is that judges don't, except unless it's a bail review or a judge is retired, the judge wouldn't typically have the authority to touch another judge's 58A orders. And
that's why I'd like to either have a
also,
ruling on
also,
the refusal.
from a practical standpoint, there ought to be a need for some. Well, you know what, let me hear you and then I'll.
Sure, I appreciate it.
Take it under advisement.
So there's a few terms that are very difficult for trial prep in the short calendar we have. This 48 hours notice business, you know, having.
Yes. Is there somewhere that the pre-trial conditions are written down? Because I didn't see anything on the file. Is your probation officer, do you have something that?
Yes, I do.
Do you mind showing the council? Yeah, can you show me? All right, go ahead, Mr.
Thank you, Your Honor. So, Judge, you know, we have about 3 weeks before trial, and I really need to start to prepare with Ms. Fitzsimmons at the office. And the 58A provisions are just very difficult, and I don't think they're really necessary in the sense of, you know.
Tell me what you want.
So what I want to do is I want to be able to call up Ms. Fitzsimmons, and I want to say, get in your car and drive to Boston and sit with me at my office for 3 hours on like a day's notice or a few hours notice. And, you know, she's on this. So 48 hours notice, you know, like, it's just, I'm a bit of a moving target these days, and it's just, it's something that, it's just immensely difficult to coordinate. I almost said ADA Coakley. Attorney Coakley and me and Ms. Fitzsimmons and my paralegal and her mom. Remember, her mom has to chauffeur her around. She's the custodian. Yeah, sorry, I mentioned earlier. So it's one of these custodial things where her mom has assumed custody of her. And to leave the house on this 48-hour notice, Ms. Fitzsimmons, and I don't know why, but she can't drive. I want it, but should there even be notice, Judge? She's on house arrest, she's got a bracelet, she's got.
There has to be notice of these wise because, is she on a GPS, right?
She's on GPS, Your Honor.
The alarm will go off. Well,
So that's what I'm asking. So I'm gonna give you what I'm asking at first. Sorry. That's fine.
You're more than welcome.
So I just want to be able to have a normal prep with Ms. Fitzsimmons in the sense of like,
2 hours.
sure, absolutely, perfectly fine.
I prefer to probation. I agree. I have no problem with changing 48 hours, but I would prefer probation because it is a legitimate concern for them.
Yeah, well, that's why I wanted you up in the front row here, so how much time would you, like, would you need to make it meaningful? And would they have to, are you supervising?
I'm not supervising.
Who are you supervising?
It's Heather Johnson.
Same.
I know that, Heather Johnson.
Yes. The reason we would have to know, we you have to know, like you said, how much, or when she's gonna go out.
Right.
You have to open up the window.
Right.
So to open up the window, we can't do it on Sunday or Saturday, it has to be during the week when we're working. So we're able to put in the release.
Okay, so.
So maybe-
just the mechanics of
So
it.
mechanic wise, is why don't we just give her a window, let her go out from like 7 in the morning till 7 p.m. And then
That's
probation
why-
doesn't have to get bothered by it.
So that would be, opening up a window with no parameters would be something I wouldn't feel comfortable changing over the Commonwealth's objection, without knowing again, I guess there's certain things that I'm happy that I'm willing to do to accommodate some changes where the Commonwealth isn't objecting extraneously, where there's some uncertainty about my authority to do so. So let's see what we can agree on, and then, so.
I just like to get her a little bit of freedom to be able to sort of a little bit more on the fly, if you will, kind of get in and prep with me and come to my office and, work on the case.
But there needs to be, so I can tell you this, is that I'm not gonna open up a window, just some standing window. I just wouldn't do it for any defendant. So to the extent that, and Ian, I see that as a significant change that, again, we would need to determine whether Judge McCarthy would hear that or not. So why don't we try to be practical and work on it?
So if the court's willing to do a 2-hour window, we would appreciate it.
Would that work if it's during working hours?
Usually during working hours, they could reach some information to the other window. So I don't know exactly why they put the 48-hour window, it's not my.
Right, no, I
But usually I say 24 hours. In some cases, I don't know, specifically for this case, I don't know why.
So here's what we're gonna do is, we're gonna try to narrow it down, and then I'm gonna step off the bench, then we ready the motion, and I wanna just take a look at PA, and then we'll come back and I'll change what I think I can change. All right, so,
Thank you, Ron. And just before you go, if I could just,
no, I'm not going anywhere.
Just
yet.
gonna-
I wanna hear all.
Yeah, okay, thanks. So we'd appreciate if you could do a 2-hour notice requirement. Her mother chauffeuring her around is an immense hardship. She works full time, and it's not fair to have her drive to. Ms. Lauren Page, there was some custodial determination that.
Custodial determination, an order as to where she should live is different than driving somebody around. Is there like a no drive issue? Sure.
So this is one of those things that, it may have been said from the bench that Ms. Page, her mom, needs to be with her when she goes out and that she can't drive herself. There were a lot of pronouncements from the bench, and, we don't want to.
Somebody in the front row home here, is there some order that's prohibiting this citizens from driving?
Honestly, I don't remember that. But having said that, I was up here when I got this, so I don't have my file with me or.
I don't see, I don't see any. Yeah, I said that. I do see provide proof of appointment to probation, we can read our notice. But I'm not seeing any, occasionally you'll see a judge of the order that the defendant can drive, operate a motor vehicle or anything like that, but I'm not seeing any.
So, I'm just trying to comply with the plethora of things that were handed down from that bench, Judge. And what happened was Ms. Page was brought up and put under oath, and the court made all sorts of pronouncements, verbal pronouncements, that she couldn't leave, that Ms. Page had to be with her at all times. She had to drive her places, or at least be with her when she went to places. And, we don't want to.
It's not in the written order.
Right, I understand, and I'm trying to do the right thing, and that was what was said by the court. And so we don't want to run afoul of anything that court said, but there were an incredible amount of things that were put out.
It's not the written order, you're not running a file.
Okay, and if the court's gonna have that for me, and then I very much appreciate it. And if she can do that, that's what I need, is that she needs to be.
The Commonwealth isn't claiming that there's any conditions that have been imposed that are not in the as far as you know, it's.
Yeah.
So I would appreciate the court protecting me on this by making a ruling that the written order is the order, and we will comply with the order, certainly. And, you know, it's almost like an integration clause in a contract, you know, all these verbal pronouncements ought not to be enforceable.
I have no idea about I can tell you is that my ruling is you comply with the letter and spirit of the written orders.
Thank you. That's all we need. Thank you.
All right, so what else do you want me to change?
Ms. Fitzsimmons,
I'm sorry, consider changing.
I appreciate it. Ms. Fitzsimmons is working on her own residence versus living with her family, which is, you know, difficult for an adult at this point to live with a family. She wants to have her own.
Working on, you're not asking that now.
She has a place and she has a lease. She's not going to sign it unless the court says it's okay. But she wants to have her own place in Newburyport. And if that's a bridge too far today, I understand.
That's a big ask right now. And I'm not saying that, let me say this, is that on the 12th, I'm going to try to get some clarity on what the law is, that to the extent of what I'm,
All right, thank you. So Judge,
but I'm not saying that I wouldn't, I'm just saying that it strikes me as something that is a significant material enough change that
I understand. So what we're looking for today, 2 hours notice, she can drive herself, she can leave the house, come to Boston, work with us at the office, drive home, you know, without fear, and she has a lot of fear based on how this case is unfolded about running afoul of anything. She got sent back to jail when she couldn't blow into a scram machine, when her rib was literally blown up, and she got sent back to jail for it. So she's pretty terrorized, and I don't use that word too hyperbolically. And so she's very scared to do this stuff.
So, I understand, but again, my view is that she complies with the written order, the spirit, and the letter of the written order. Actually, really just the letter of the written order. And she has no, she will not run into any trouble with me as far as I'm concerned.
All right, appreciate it.
But let me, anything else in the bill, because I must step off the file and just take a look at PDA. But right now, basically, what's before me is a request to change the notice requirements. And you want that change on other appointments as well, like the doctor's appointments?
Yes, please.
I mean, it does seem like those next appointments would be set up for, but it's kind of objective if I change all of it.
Well, it's my understanding that she's on a schedule where she meets people as far as that goes. I was assuming that probation and the defendant were on the same page about when she was leaving for these appointments.
She has some Zoom mental health appointments that she takes, but you know, I don't see why.
Let's just leave the timing on the mental health, on the medical and mental health appointments the same way it is, and then I'll have a better answer on.
Thank you.
On the 12th, whether it's something that I would all right.
And then the last thing, Judge, is the, you know, this order that she can't go, essentially, that she can't prosecute a custody case in probate court, family court. There's an order, and this, you know, this may be one of these verbal pronouncements, but there was an order that she may not, and I believe there was a written, this was written somewhere, that she cannot she has to stay away from her child, and that, in essence, any probate or family court custody order does not supersede that or can't affect that. So the Superior Court is basically telling the family court, we don't care what you do over there. We don't care that you're the experts in this. You can't go near your child, regardless of what the probate court says. So Ms. Fitzsimmons is in this custody case over there that's stalled.
I think I can truncate this, and that is that there is a provision that does say have no contact direct or indirect with victim witnesses and only child. And that must be what you're referring to.
Yes, and there was an even more explicit pronouncement somewhere,
So
regardless of probate court.
again, I need to think about whether this is something that I would entertain or not. But does the Commonwealth, would the Commonwealth object if I were to entertain changing that to be, comply with? She's already ordered to comply with all court orders, which includes probate court orders. We are not the experts in the probate court is the experts in custody, visitation, they handle all that, so I wouldn't want to get fired into that, but I don't know, I wasn't here to hear.
Yes, that's the problem, that you're in a position that you know nothing about the hearing, nothing about the evidence that the judge looked at, heard, and considered when she did that issue. So,
So the Commonwealth objects to the, perhaps that would be something that could be, again, reevaluated on the fall. Anything else, then we just step off a couple minutes and check it over.
I just have trouble with the idea of the Commonwealth even having any standing to object to, where Ms. Fitzsimmons can go, which court she can go to address child custody issues when the child's not a witness. The child had nothing to do with this.
The Commonwealth is not saying that. I don't understand, at least I don't understand the Commonwealth saying that. The Commonwealth is by reading this, the Commonwealth is saying very simply that there's a condition of her release under a criminal statute. And this is what the judge ordered, and you're objecting to it on the grounds, I don't want to speak to this person, the grounds that this, like all of the orders, was part of a framework for the release, and again, this may or may not be something that I would entertain. All right, so anything else before I step off?
Just the last thing, Judge, and I know and I respect and I appreciate that Your Honor wants to defer to the other judges when there's other rulings. Obviously very common in our system. But in this case, I can't fight against the ghost. The court made a very strange ruling where I filed a motion to recuse her for bias and violations of the rules of judicial conduct. Perhaps wisely, Judge Ricciuti intercepted that motion, which we all know was supposed to go to that trial judge. And in 24-hour turnaround, he said, it's moot. She's going to be in another session or to that effect. And so she's either out of the case or in the case, Judge. And, if I can't have my client's liberty hindered, I want you to feel free to make rulings on this case. And she's either in or she's out. And I think Judge Ricciuti assigned you the case. I don't know what happened, but here you are, and I'm glad for that. But I feel like you need to be free to make the rulings.
Very well may be the case. I don't know. Again, I'm starting with the assumption that Rule 58A does not allow me to make those changes. And let me take a look at the statute. It is a bigger issue. I don't think that I've been in the order of assigning you this case. I was assigned the file. But it makes sense for me to take everything. So just give me a couple minutes.
Thank you. Thank you.
All right.
All righty there. I'm just going to keep the screen on, the courtroom on, even though there's going to be no sound, because as long as we can get some pictures of this, we will get some pictures of it. And as soon as it goes off, I will take it off the screen and wait, hopefully, for Michel Bryant to get on, or I'll leave this on the screen because I know that both Michel and Amanda will be covering any press conference that Tim Bradel will give. Hold on a second. I just have to turn my phone off here for a second so it doesn't keep coming through. So that last half an hour, I know, was just all of us are we're just right. We're, oh my gosh. And Tim Bradel it really has done a remarkable job within what he has with regard to this judge. And quite frankly, the judge did give him something with regard to the bail, and is assuming, however, that Judge McCarthy Naaman will also want to support Kelsey with regard to the letter and spirit, because he did say, look, I'm going to give her 2 hour you 2 hour notice, and she can drive herself to your office and I assume all will be okay, because all I really want to make sure is that she complies with the spirit of the ruling. But I really don't have the authority under the court rules I operate on to change the bail motion. And then Ted Bradel's been trying to say, but Your Honor, we filed that. Then the assignment judge, whatever you call them in the jurisdiction, said, look, we don't have to deal with this recusal motion you filed on Judge McCarthy Naaman, because it's now moot, because Judge Karp, who we heard today, is taking over. Well, Judge Karp says, I can't take over because I have no order from anybody that says that I can take over the issue of the bail changing of conditions, because the rule says that another judge can't change the bail conditions invoked by another one judge. So Bradel's like, I'm fighting against a ghost here then, Your Honor. I have the assignment judge basically who says McCarthy Naaman's out of it. You're in it. I have you saying you can't do it except for what you did give us today, because you're trying to help us and we really appreciate it. What do I do? So I guess my thought is that he has to go back, Bradel has to go back and refile the motion to the assignment judge, or whatever you call that judge that moves all the judges around, to say, look, I'm limited here. Judge Karp said he could help us, but he couldn't really help us with a formal order of the changing of the bail. I'll give you some relief. I'll give you some ruling from the bench, but I don't have the authority to undo all the conditions of the bail. So I guess that's where at least he's gotten some idea of what to do. And in the meantime, I don't think that Judge McCarthy Naaman would revoke Kelsey's bail if it was different than what she ruled from the bench, including the fact that the mother had to drive her around. And I remember that. It may not have been the formal order, but a mother had to drive her around. But what Kelsey is terrified, and rightly so, wouldn't you be, to even drive to the office? Will they stop her and say she's drunk? Will they stop her and say she was a danger? Will they stop her and say she went through a red light? So really, you're going to have to hire a driver for her. You're going to have to hire a private investigator to drive her, really, and that costs a lot of money. Because you have, she's not a danger. Look at her. Look, she's after what we saw yesterday. Now I know all of us are in a little bit of a tizzy because the judge didn't really want to deal with the motion to give promises, rewards, and inducements, and that's why the way that Tim Bradel did phrase that motion was incredibly brilliant, because the Commonwealth says, well, we really can't respond to it unless it's by affidavit. Well, wait a second. If you know of some of rewards, and let me just stop a second, because I have my co-host Michel Bryant, who's just texting me, and let me ask him. I am on the air with our viewers. When will you be able to jump on the link and possibly even show us the presser? As we've been talking about this, and everyone wants to know what you felt about being in court. So now you know my communications with Michel Bryant by text. It just seemed like he didn't want to do anything with regard to that. And but we did learn a lot. I mean, Brado did learn a lot by filing this motion. Absolutely learned an awful lot, as we talked before. He learned that the Commonwealth is really trying to find a way not to call Justin. He called him alien, and then he asked, "How do you pronounce his name?" And it said Alain. So you know, somewhere along the line, Michel Bryant has come into the psyche of all of us by calling baby daddy Justin alien. But apparently, it's Alain is the proper name. I just call him the baby daddy. All right. And the prosecution, by the way, we learned that the prosecution here in Essex ruled that they weren't going to charge him when Middlesex ruled that they weren't going to charge him because they found no probable cause that he had done anything wrong because he had called the police to say he was going to go to the house. But the police can't give you the authority to break into a house that's not yours. I mean, here in New York State, we have issues with squatters taking over empty houses that are waiting to be rented or whatever. And even the owners can't go into the house without being charged with a violation of the squatter's rights, because then the owners, and there's been high profile cases, are getting arrested. So I don't know how the police in Massachusetts can give you the ability to break into a house. And they certainly, you know, I mean, if they did, I mean, I really do think that there is a civil rights suit here with there's a deprivation of civil rights on her with Justin alien, Alain, baby daddy, possibly with the other three people that are involved. We named them, by the way, this morning. I'm not saying they should be in a civil suit, but that's a possibility. But with regard to a 42 U.S.C. 1983, because you have the involvement of law enforcement taking away the civil rights of somebody with a private person, and that's Justin, the baby daddy. Okay. Now, as I said, we did in law in our Twitter account under Justice Served TV did name. We had a sourced the names of the people that were in the house, and if you go to our Twitter account, which is at Justice Served TV. By the way, Michel Bryant was live tweeting what was happening in the courtroom on that Twitter account. So in case you were just watching me, you can go back to looking at it, because Michel Bryant was live tweeting the effect and how Gubitosa was acting and how everybody was acting. But based on our reliable sourcing, the three people with baby daddy Justin Alain at the alleged break-in were his brother Brendan, friend Hunter, who is a Haverhill, Massachusetts firefighter, and we haven't confirmed, but there was he may have been a North Andover firefighter previously, and another unnamed North Andover firefighter whose name we weren't able to source, but he was apparently the tall one in the group if you look at the video. So there may be more information out there, but that's what our sources said, and we did name that this morning. Okay, so there we go. So this is really just a way, by the way, for a new member to join us, US Lily 80 new member. Thank you for joining us, and to see how the criminal justice system may or may not act. Now,
Maybe we're back on record on the Fitzsimmons matter. All counsel and the defendant. All right, so folks, we're going to need to wrap up. Give my thoughts on the pre-trial conditions. That is the following. Is either side object to me specifically asking the Judy to assign me to this case for all purposes?
No, Your Honor.
No. Okay. All right. So then that will give me some certainty about whether I'd be violating some statutory provision by making changes to the pre-trial conditions. So I'll reach out and try to get that taken care of. I am going to change. We'll talk about the language in a moment. I will change the 48-hour window with the attorney's visits to 2 hours. And then I'll tell you this, Mr. Brado, and we're going to do that right. Yes, but going forward, I will entertain the rest of these requests that you've made on the 12th when we're back in, because my hope is between now and then I'll get the formal appointment.
All right,
And then I'll feel more comfortable about having the authority to change it, to make the changes. And then, but I will say this though, my thinking is on the issue of the order related to no contact or stay away from the child is, I would need to see, because I don't know what I don't know. What is the probate court involvement with the child? So you don't need to answer that. I'm saying, what I'm saying is that, if I can be provided some documentation so I know what it is, in other words, some documentation that shows me that the probate court is addressing, contact, visitation, custody, whatever is related to it, because I did, there was a provision, if I remember correctly, in the 209A, where the probate court ordered, I believe, that at least temporarily custody go to Mr. Ayala. So if I can get some sense, because that's all I know of what the status is, some documents, then I have more information to be able to change that. But
Appreciate that.
But it makes sense if that's the case.
Well, with the caveat is you had said earlier, you know very little about this case, so I'm assuming the exhibits from the 58A are in the file, and if they're not, so you're on to review it.
Let me be clear, when I say no little, I know all that's in the file, and that includes, I've read the police reports, I've read the Dr. Zagzala report, I didn't see grand jury minutes, but I've read, so, and
The training affidavit, there's another report in there, talking about her long-standing issues and things like that. So,
let me say this, I will not make any changes without knowing, having all the evidence before you. That goes without saying.
And I can just tell you just what's coming, Judge, in terms of documentation. So, and I hope this gives the court a comfort level, is that there's the restraining order that he got in family court is still there. So, so
it's not a matter of comfort level.
Right.
It's a matter
nothing would happen if the court says, we're vacating this, we're leaving this to probate court. What you'd be leaving it to is an existing restraining order that hasn't had the benefit of a two-party hearing since going back all the way to July, or June 30th. So that order is still in place.
But that's something that this Fitzsimmons can do something about. I mean,
It's tricky. It's tricky because it's a bit of a catch-22 because you got the family court judge looking at this saying, well, I can't do anything because Superior Court's telling me I can't do anything. And Ms. Fitzsimmons has another counsel for the custody case, and she's sort of waiting in the wings to see if we can have Your Honor address this, no probate court order. And once that happens, I think then we can address all these things in family court.
So what I would ask from the Commonwealth, actually both sides, that at some point you take a look at the file and make sure that I do have that everything that I need to know of the 58A and the terms are it's in the file. And again, I've already talked about the court-related documents. And whatever else it is that you've raised on the conditions, changing the conditions, again, we'll address on the 12th. And that assumes that Chief Chudy assigns me, assuming will happen. And that's where we'll leave it. So let me,
no, I think we're wrapping up. I just need to put one thing on the record.
Yeah, I'm not wrapping up yet. We're getting close. I promise the staff that we're wrapping up. Officer Nunez, so you have this order, or this, I just gave this random. How can I change this? Can I make a change on this?
No, it could make it. You can do some work. If you want to change on that, you can actually.
Don't make me. Let me just, here, I'm going to change it on here, and if you can make some kind of a document that, so. Allow out for medical. Note there's a provision here. Change the attorney visits with 2 hours notice. And remember, Mr. Grader, we're talking about during the week, so I know it's for a weekend.
I do.
Right? And like any trial attorney. And so if there's gonna be some meeting on the weekends, she can't.
Gotta respect the 2-hour notice.
That's
No,
48.
she's gotta set that up during the week while probation is
Oh.
around.
Oh, okay, I see.
She can't just
Certain-
pick up Saturday.
Well, I was hoping to give probation like a schedule of meetings for like a week and a half.
I thought you couldn't do that.
Well, if I have 2-hour notice, I can be more flexible. I can't do 48 hours. 2 hours I can manage. And I appreciate your honor doing this. There's a lot of provisions in here that the court needs to look at and grasp and get up to speed on.
So we change that. So I just wrote in that. What I would do is let's make a copy of that document. And you can do copies to each side of have it. That's the only thing that changed. And of course, after deadlines, which was going out, maybe I'll do some procedure work. What else?
I just wanted to put on the record, that council had listed just really 3 things that he was missing. Detective Furman's report, he actually has that. The body camera of Sergeant Strong at the hospital, he actually has that. I'm gonna help him find it in the discovery. So the only thing outstanding is the OneDrive link, which will be Monday, and my email to him memorializing what we just talked about. After that, I'm filing my final.
Thank you, Your Honor. That's appreciated. Thank you.
Let's all work cooperatively. It's something we folks have. And let's get this thing to trial. All right. Okay. Anything else? Otherwise, we will.
No, just the conditions of the officer.
Oh, you're right. Give me the other one. So I wrote 3 visits for 2 hours. And there's no probation. So that actually, this is probably better than I changed both orders. So that is it. Okay, so we'll see you back 9:30 on.
Thank you.
Thank you, Your Honor.
All right. What's that doing?
Yes, sir. Yep, she'll be right here. Okay.
Right, I think the sound is going off here and
The best
yeah,
word I
okay.
can use to
We're
describe this journey is
unshare the screen.
unpredictable.
Okay, hold
What
on
may
one
not-
second. All right. Okay, I think that I unshare that screen. Now it's very possible that Amanda of Law Girls, Not Attorneys, Due Process will be sharing the press conference. Michel Bryant will be going to the press conference, asking questions, and then we'll be reporting back in here to have a discussion before he sets forth in his car for his 3-hour drive back to meet his wife for a very belated birthday dinner, it would appear to me. But we're going to stay on here. Let's see if I can look at, and if all of you find the presser being, it's hard for me to do this when I'm on the air speaking to you. By the way, did you notice the prosecutor referred to what Justin Alain, the baby daddy, Justin Alien, did as a breaking and entering? Did you notice that? Okay, that I don't think he intended to, but he did refer to that as a breaking and entering. So there we go with that. That's really, really interesting. But Michel Bryant can step in at any time, you know, if he's setting up, if the press conference goes, you know, however it goes. I mean, and maybe we'll just capture it and we'll run the actual press conference, right? And the, yeah, they are classic. Yeah, you heard that too. Yes, you did hear that. Now, I was telling you before, the reasons Massachusetts is really crazy when it comes to these microphones. And thank you for Michel Bryant, because as you know, he is an Emmy Award-winning newscaster. When he does it, he streams the microphone back. You can only put one in up to the lectern or wherever it's going to get the best sound. This time he told Amanda to put it on the counsel table, on Bradel's counsel table. That's what we heard Bradel so well. The prosecutor a little bit less well, and the judge not as well, but he didn't really do much. So that wasn't a big loss, okay, with regard to that. And also the other network from Boston that was streaming it, they weren't going to use any microphone in the past, but Michel Bryant told them they needed to put a microphone on counsel tables so that when that stream is caught and you can go back and look at either of them, you're probably going to get the same sound that we're going to get. But if it wasn't for him, no one would be doing anything with regard to microphones and all. So, you know, the judge seemed like he was unprepared with some part of the motion, and I'm sorry that I'm looking. I'm just seeing what Michael has to say, so it's going to be a little bit before he gets on with us right now. And all. So why don't we just go through where we ended? You know, the judge left the bench. I think he actually called the assignment judge because he mentioned something about the assignment judge. He mentioned that Kelsey would not get into any trouble with him with regard to the bail conditions. However, the bail order is still in existence, even though he said he gave permission. He gave oral permission, and that's what Tim Bradel said. Judge, I need something to protect me. You know, well, you have it. You have this oral. You're gonna have the transcript of this. That Kelsey is not going to get into trouble. On 2 hours notice to probation, which probation already had said they could handle. She can go to Bradel's office and she can work with the team or who's ever there on her case, and she can drive herself. All right. But look, either McCarthy Naiman is in or she's out. And I thought she was out. So did Bradel thought she was out. How could she still be in? Because now Judge Karp said, and I put in somewhere in the chat early on his credentials somewhere, he said, because Rule 58 prevents me under the rule, and I can't violate, from changing the bail conditions ordered by another judge. But I'm going to say you can do this, you can do this. I'm not changing the bail conditions, but I'm adding things that you can do that really are exceptions to bail conditions without changing. So it's enough to give you a headache. You know, you're the judge. Make the ruling. You've been told by the assignment judge that the issue of recusal is moot because you're now it. So make the ruling and let the assignment judge yell at you. So I really think that he actually called him, and the assignment judge told him he could make it. But I think Bradel probably has to refile that motion now and say that Judge Karp is in the case, and this court should give complete authority to Judge Karp to should recuse Judge McCarthy Naiman, and complete authority rest in Judge Karp. So I think that's why Bradel was working so hard, because he felt he was going to get a good result from Judge Karp with that 2 hours. And that's something that all defense attorneys can possibly work with, because the 2 hours is like, you know, you can text the probation officer who's obviously in litigation because of Judge McCarthy Naiman, and say, look, she's going to come to my office in 2 hours, or she's going to come to my office or whatever at all. But that means she can leave earlier, right? It's just 2 hours. It got to me that it was 2 hour notice of being at Bradel's office, not 2 hour notice of her driving her car. So I think the letter and the spirit would prevent Kelsey from getting into trouble, unless, of course, they want to go after her. And I don't mean they as in they, Judge Karp or anyone associated with. I mean they is the proverbial they that we see with Karen Reed, right? In the Karen Reed case, right? That's what that's the day that she's terrified of, and therefore you really do have to let her go out with some type of whether it's police protection, that's private police protection or whatever, but that's expensive. That's very, very expensive. I mean, she's already got donations trying to deal with this. Can you imagine? I was just thinking about this last night. And just imagine that you are so excited. You gave birth. You're so happy. Your life is, you're giving birth. You're going to get married in 6 months. Oh my gosh, healthy baby. And you end up with postpartum and you deal with it immediately. And you go get the help that Brooke Shields and all the women for years have now been talking about, that so many women have postpartum depression, something that was acknowledged overseas in Britain, and all postpartum psychosis was acknowledged overseas in Britain. Even if you killed your child within the first year, it's not considered murder if you're in postpartum psychosis, because of the hormones and the biological changes that cause you to have these problems. And then you deal with that. You have to give up your gun, and all. And okay, you're with that, and you're thrilled, and you're happy, and you're breastfeeding, and all of a sudden, and your baby daddy moves out. Okay, now you think there's some problems. Okay, he moves out. Okay, but maybe they'll be resolved. And he calls you. Can we meet at the park for a lovely walk in the afternoon with our child? And you go and you sit and you wait in a park, and you've got the baby stroller and all. And you're tiny, and you've just come out of the postpartum, and you've just gotten the ability to get your gun back, and you're about to start now your job back again, and your life is going to be okay because all these issues are going to be behind you, and you end up finding that in comes your partner. They pull the baby from your arms, just like in some foreign countries who pull children from the arms of their mothers and they never saw them again. You run upstairs. You can't believe this happened to you. It's like your whole world everything starts falling in. You're going to shoot yourself. You end up getting shot because some officer says you're going through the door. You're going to shoot him when there is no door. Okay, and you're fighting for your life for over 30 days in the hospital, and you're still fighting for your life because you still have the effects. And in the meantime, your husband to be, luckily it was only to be, has taken your child away from you, and then the state tries to indict you for attempted murder of Noonan. They call you all sorts of things. They prevent you from seeing your child. Your parents are prevented from seeing your child. You're fighting for a year. You're put back in. You can't, you have shrapnel in your chest, just like if you're an Army officer. You can't breathe. You're told to blow into a scram. You go to the court it's supposed to be fair to seek relief, to say, look, can you just lighten those conditions? I'll take any of the testing you want. I'll 5 times a day if you want me to take any type of testing. The court lies about you, finds you a danger, says you're terrible, makes up all this stuff about you. All right. I mean, who wouldn't be emotionally upset after that? And then you get sent to jail for 110 days where you are. And in the meantime, your baby again is taken. You cannot see your baby at all. And then the court that's dealing with the family issues says, well, you can't see the baby because Judge McCarthy Naiman, who's dealing with whether you're dangerous, says you are not allowed to see your baby in an order dealing with a criminal matter. When you don't get indicted, when the grand jury rejects the attempted murder, and gives you an indictment that can only put you in jail for a limited period of time. All right, not that that's good, but it's better than it was, right? And then there's all this fights with the grandparents and all. And then you find, and we find, that not only 3 days while she's in jail, her house was being broken into. And I will say that. I don't care, because there's no way, in my opinion, the police can give somebody permission to break into the house of another. That house belonged to her. She's female. The days of the man telling that they can go in the house no matter what were supposedly over a long time ago, at least in this country, right? All right, it's just heartbreaking. It's absolutely heartbreaking. And now you find out that, and I am sure that when Middlesex decided not to say they weren't going to charge him, because they probably figured this is a family affair, right? It's a husband against a possible wife and a child involved. Just this little family affair, and he was living there until 3 days before, and therefore it's okay for him to go in. You know, that's probably the mindset that they had. And then this county comes along and said, because Middlesex said they're not going to charge, we don't find any probable cause to charge. But did they have the information last August about the computer and what happened to the computer and money being taken from it and all sorts of other things, right? Did they have that information? So you go before the court now because you have a March 12th trial date, you know, you have a, March 12th, next date. And the judge wants to get this going. He wants to get a trial going within the next month, by the end of March 27th, I guess, now. And you can't even get any relief from that, all right? You have to feel defeated. You have to feel that the world is against you, that there is no justice in the courts. And quite frankly, I'm feeling that way. I'm feeling that way for her. No matter how hard this judge wanted to say today that, look, and the judge didn't want to deal with this stuff. You saw, he didn't want to deal with this stuff. He just wants to get the trial and get it over with. But one of the things, there was a lot of consternation, I know, last week about what, you know, Kelsey made the video that some overlord on her Facebook page said it was supposed to be a private video for them. Anything on the internet is not private. All right, let's put it that way. You just assume anything you say is like you're in the middle of a football stadium anywhere in the United States of America, or in, you know, overseas if you're in the middle of a stadium of any sort, right? And your heart broke for her because a year after her baby's born, she couldn't see him, right? She couldn't see him. I think anybody, I don't know how you felt, but I thought anyone who saw that video is never going to convict her. And I think this motion yesterday, you know, was designed to do more than what just try to get discovery. It really set the prosecution, set them down in their position. Bradel did get a lot of information, and I think it also affects the jury pool. Now, we as lawyers are not supposed to file motions to affect the jury pool, but I'll guarantee you that this one did. You want to tell me, is there anyone that's going to convict her in this chat? And you're the jury pool, right? Let's say you're the jury pool. I wouldn't convict her. I wouldn't convict her of anything. As a matter of fact, I sent a note out to the judge and say, when are we going to hear the case against the people that broke into her house? When are we going to hear the case against the state for not doing the job? And you're a taxpayer in any of these counties, Norfolk, Essex. You got to be wondering what are your tax dollars going to? I want real crime dealt with. I want the kind of crime like Mrs. Guthrie, like Nancy Guthrie, 84 years old, sleeping in your bed and you're not safe in your own house dealt with. That's what I want to do. That's what I want dealt with. I want to be able to walk down the street and not be assaulted or attacked. I want to be able to sleep in my own house and not have the fear of somebody coming and shooting me or kidnapping me or killing me. You know, that's what I want. I want crime dealt with. This is not crime. All right. I mean, if they want to say that Justin, baby daddy, could break into a house, then they should be able to say that somebody who just came out of postpartum depression with a piece of, excuse me, Justin, because I don't know you, but I think I know you, piece of shit, okay? The only problem I have is that Kelsey somehow didn't have the good wits to not get involved with him. And now she is stuck with him for the rest of her life because she has her baby who she loves, who's half his DNA is baby daddy's DNA, okay? And this is the baby daddy and his family, and let's not forget his family, who apparently, according to our sources, brother was another one who broke in. I'm using that term generically, not necessarily legally, to her house, right? And won't let the other grandparents see the child. All right, that's what we have here. So, is there anyone here who's going to actually convict her of the charge for which she was eventually charged? I can't wait to hear why Newman was on Flexerol, because that's not an antipsychotic drug. That's a muscle relaxant drug. And so I think we heard hints today. The other thing I think we heard of is hints that that maybe Noonan has some drug issues. That's what I think Bradel kind of was hitting at, right? Didn't you hear that? Didn't you hear that? I thought I heard that. And that he wanted to see whether there was, why there were no specific maybe charges or departmental charges against him because you take too much Flexerol and you oversleep, all right? How much is too much Flexerol? How much do you have to take to oversleep? Have you taken it before? Do you have do you have some kind of buildup in your system that you're immune to a normal dosage? Did you have to take something more? And Newman was also one of the ones that came in to take her baby away from him, and he was her partner. He was her partner. All right, so something really, really stinks. Okay. Yes, I'm just seeing some scrolling as I'm going down. It's been hard. It was hard for me to watch all the scrolling. I know at some point there was some drama in the scrolling. I was ignoring it because I can't watch the regular comments, and I can't talk to you and listen to what's happening and text with Michel Bryant and give you my objective opinion, which is objectively how I feel. Now maybe it's not objective, like, I'm not going to say, oh, there are two sides to every story, because I don't think there are two sides to every story in this case. I really don't. I think there's one side to this story, all right? And that's everyone should be working to make sure that baby's best interests are protected. And I think everyone should be working to make sure that Kelsey is well and all. Let me just say, made of questions. I think Bradel did very well today. I think his goal was to alert the judge and all. And I do. I think Bradel, there's ulterior motions for this motion, and the way he phrased it, with which to get the rewards and inducements, prevented the prosecutor, although the judge did start by saying, well, why isn't there an affidavit? Well, there's no affidavit because this is not really a motion for dismissal or a motion for discovery violation. This was a motion to get discovery, to say, we think we're owed more discovery, and you therefore on notice under the new Rule 14 that Judge Beverly Cannoni was the head commissioner for, to break that rule, under notice that you have to look for this stuff. You have to look very hard for this stuff. And until you say you look for it and it's not there, our affidavit and our discovery compliance does not come in, right? Our affidavit and our obligation of discovery compliance does not come in. So we had that. We also heard that there were OneDrive links that were provided to Bradel, and Bradel told the prosecutor they don't work, and he's waiting for working OneDrive links. I don't know how many times you can screw that up. Okay. All right. Eldon, and I'm not just doing start comments. I'm just picking a comment. If I look up and I see a post, can Mr. Bradel take this to the feds? I think he can. I think Martha Coakley is why she's on this team. She's on this team because she was the prosecutor. Was it Middlesex County? Was the head prosecutor of Middlesex County, or was it Essex? You can look her up. And then she was attorney general, and she ran for some higher office and didn't win. But she's the one supposedly, I think she's put on this team supposedly to have that juice, to have that interaction with the higher offices, with the feds, with the state. Where's the attorney general of the state of Massachusetts? They seem to be nowhere in any case. They weren't around Bob and Karen Reed, Sandra Birchmore, Matthew Farwell, and now this case. I don't know who the attorney general of Massachusetts is. I think it was Middlesex too, Gloria. I don't know where they are, but they don't seem to be doing anything in cases that we're seeing. I mean, and as I said, when we tried Aaron Hernandez, we obviously had a good judge. He was still a judge, and he was still on the side of helping prosecutors. But we had decent prosecutors. We really liked the prosecution team. We thought that they were honest, objective, and terrific. All right. And we won the case, double homicide after Aaron had been convicted of a murder. We got her not guilty. So we, even though we had our skirmishes, shall we say, and sometimes we had rip-roaring fights with the judge, sometimes I will say, he was fair. And I think I've told the story that at one time when we really had a rip-roaring fight with him, because he dressed down one of the attorneys in front of the jury, which is something we objected to. He brought all of us to the side bench, and he said, "What did I do? What did I do?" Because he hadn't realized what he had done. That was in Suffolk County. All right. That was in Suffolk County in Boston. So I had, so obviously my experience with the Massachusetts courts have been excellent. This has not been so excellent watching this. It's like no one has the gumption to say, okay, prosecutor, this is bullshit. Here's what I think the judge is wrong now. You as a judge, if you see a conflict of interest, you have a duty to call that out. You have a duty to say that, because if the case is tried with a conflict of interest, it comes back and gets reversed on appeal, right? You say, prosecutor, you do have a conflict of interest here. So don't we have Didn't we have, it wasn't judge appointed, I know that, but don't we have special prosecutor Cosgrove? So we all know that special prosecutors can be appointed in Massachusetts. The prosecutor has an ethical duty, if they have a conflict of interest, to then get a special prosecutor. I don't like special prosecutors, but at least they recognize a conflict of interest. So what does it take? Does the prosecutor want an ethics charge to be filed against them to say you have a conflict of interest and have the ethics panel, the ethics board ruling? It's not called the ethics board, but you know what I'm talking about generically. Massachusetts say you have a conflict of interest. And that's where this became interesting. I'm going to tell you again, this is where this became interesting. Bradel pushed, all right? And some of you say he's too straight, but he knew what he was doing. He pushed to see about the conflict. And he pushed to say you have a conflict because your recipient, or as they call it in Massachusetts, an important witness, one that will make your case, is baby daddy. And you have a conflict if you've determined not to charge him, because if he's one of your witnesses, maybe that went into the brain matter of not charging him, and the determination of not charging him was the fact that he was going to be your witness, and you don't want your witness charged or dirtied up, right? And so he gets from the prosecutor that due to the not even that he wasn't charged by Middlesex, and therefore they weren't going to charge him, but that he's not a precipient witnesses, that he was in the basement, he didn't see anything, which tells me, as I said before, that the prosecutor is thinking of trying this case without him. Just like in Karen Reed 2, remember Karen Reed 2, okay, where Proctor wasn't called, right? The prosecutor found a way, Hank Brennan found a way, didn't backfired, not to call Proctor because he knew that he would be too dirtied up, right? That's what they're thinking here, that there is simply no need to call baby daddy here, because they can rely on court records, they can rely on what happened, they can rely on all sorts of other people to say, this is how we got here, and then we ended up at her house, and she intended to kill Officer Newton. But it wasn't murder, it was by use of a dangerous weapon, right? Instead of herself and all. But we also found out there were some other things of discovery that definitely were missing. Yeah, I think they know Justin is dirty. And I think that you have to see, I mean, I don't know how many people tagged North Andover Police Fire Department today, but I know a lot of people did. They certainly tagged this Essex County prosecutor, who obviously is not going to back down. He's going to continue this case and all. And he gets a little bit of support by the judge who said, let's get this to trial. We know that the surveillance video was actually given, there was a surveillance video given today, okay, from the system. All right, so Bradel took that. He said he had 8 things to discuss. It was actually 9 or 10, by the way I counted it. That he doesn't have any experts' opinions, CVs, notes of expert opinions, or their CVs. And apparently there's an expert, a 7-page report about the guns. And Bradel said, I think those were the guns for the officers. I don't have any on the gun that was used by, allegedly used by my client. And Gubitoso, who's the prosecutor, said, no, one of those were the service duty weapons, and one of them was the service duty weapon of Kelsey, okay? And so Bradel said, well, if that's the case, and I have all the reports, I withdraw that objection, okay? But he didn't think he had it, right? All right, so, and then, so we have that. And then he said there was a visit so we had the surveillance video, we had the expert notes in the CV, whether that was something. We had the office visit by somebody in Mass General, a North Andover police officer that was unannounced, that he didn't have any notes on. He said there was definitely a body cam video worn by a state police officer who visited her at the hospital. And he confirmed with Kelsey that the state police officer was wearing a body cam. He said he doesn't have the body cam. Of course, what they're going to say is the body cam was not on. You and I both know that the body cam wasn't on. Yeah, I was wearing it, but it didn't record anything. All right. So we don't have an answer on that. So the prosecutor has to look into those 2 things. Then we went to the promises and rewards and inducement statement, and that's when the judge started saying, well, it's not supported by an affidavit, and Bradel said it doesn't have to be. This is not any type of motion to dismiss for violation of discovery. This is a notice for them that this is an issue, and you have to give us what they have. And then we got the running of the mouth. Oh, we got the running of the mouth. Well, the reason why we don't have it is because no one decided to charge him. And then Bradel said, I want the documents, I want the text, I want everything that says you don't have to charge him, right? Then Bradel wants a witness list. Well, wouldn't that be nice to have a witness list when you're supposed to go to trial in a month, right? Wouldn't that be like novel? Okay, a witness list. Gee, all right. So that was another thing. Then 8 was the move to strike the discovery compliance by the Commonwealth because it triggered defense obligations. The judge said, I'm not going to strike it, but you'll all kind of work together on this because I just want to get this to trial. All right, I'm not going to do anything. Then there was the OneDrive links, which the prosecutor promised to get Bradel working links. Then there was redacted grand jury minutes, and the judge did rule that Bradel is entitled to the unredacted grand jury minutes because some things were redacted. So basically, these are all wins for Bradel. By the way, I know you were thinking they weren't, but they in the judge sounding like he was hemming and hawing, he was giving him these wins. And then that's when the prosecutor somehow got the fact that it ended up being back dumped to be beyond the grand jury minutes about the prosecutor said they weren't going to charge Justin, the alien, because Middlesex said they weren't going to charge him, so Exeter said they weren't going to charge him, and that the police had authorized him to come into the house, which leads me to tell you that especially if she gets acquitted here, she's got some hell of a civil rights lawsuit under 42 U.S.C. 1983, 1981. I've explained to you in the past that that's how you get police involvement with a civil person. Justin Alien is operating as a civil person, not as in his capacity as a fire department person, because that's that conspiracy. It had to do with minorities at lunch counters when they weren't being served, and to be a police officer at the other end who wouldn't do anything. And the courts ruled that's how you get the police involvement in a 42 U.S.C. 1983, 1981 conspiracy claim. That's a federal claim violation of civil rights because the police don't take action or take improper action with a normal person, a regular person like you or I. So she's got some civil suit, I think. All right. Then Bradel said he had the same issue with regard to Noonan. He wanted everything that he talked about with regard to baby daddy. He wanted with regard to Noonan. Then that's when the issue of whether or not there was a special prosecutor could be appointed, and the court said, I don't have the authority to appoint a special prosecutor, and Bradel argued, well, Your Honor, if you see a conflict of interest, you have authority to do something. That's why you're sitting up there basically with the robes, right? And he said, no, because I have a violation, separation of state duties, like in the federal system. I can't order the prosecutor to tell the prosecutor he has a conflict of interest. He can decide he has a conflict of interest. He said, but Your Honor, you should say something here because it's a conflict of interest, okay? And that kind of went round and round and went nowhere, right? So that led Bradel to ask the judge, you really, we've got issues here. You really can't order things because I don't have a certificate of compliance that's really valid because I have all this stuff still outstanding. And then the judge said to Bradel, is it your position, Mr. Bradel, that I can't order deadlines in discovery? And Bradel, of course, had to back that. No, I'm not saying that. I'm not saying that. Okay. I'm not saying that Bradel is, that you can't order deadlines, but you do have, there's certain things that you should be ordering that you're not, basically, is what he came down to. And then we came down to the bail, which the judge had said early on that he was going to try to do something about, even though he doesn't have the ability. He was going to try to help Bradel do something about, even though he didn't have the ability to undo Judge McCarthy Naiman's very violative order, including an order which no one has ever seen, where the criminal judge orders that she can't, that Kelsey couldn't see her child as part of her bail conditions, when that should be a family court decision. And Bradel said, but the family court says I can't order to allow her to see her child because the criminal court, Judge McCarthy Naaman, ordered as part of her bail conditions that she can't see her child, right? I mean, this is like Kafka-esque. This is like something, and that's an author, for those who are familiar, who wrote a book called The Trial, about how you've got this big shadow of a ghost up there, and you can't get out of everything that's going wrong. It's so bad. It's so wrong. 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 And that's basically. And he said, but Judge, he said, I can't do it. And the judge said, well, again, you're going to have to deal with something because I can't undo her order. All right. I just can't undo her order, but I'm going to take a break and I'm going to see what I can do. All right. Because he talked about helping them on the 2 hours. And Breda wanted just a window 7 a.m. to 7 p.m. every day where she could drive herself, because she said McCarthy Naaman ordered, even though it wasn't in the written order, ordered that Kelsey had to have her mother take control and drive her everywhere she had to go, because she's a danger, right? And she's a danger, right? Which she's not. All right. So, and she's a danger specifically to Noonan. It sounds to me like the only danger to Noonan may be Noonan himself and his Flexerol and whatever other issues that may be going on that Breda was trying to get access to. The other thing the judge ruled is that medical records would stay under seal. And I don't know if that's medical records of Kelsey, because I couldn't quite hear him, or if it also had to do with any type of discovery that's given as to medical records of Noonan being on Flexerol and that type of thing. So I couldn't hear that, and I apologize. And I don't think it really matters. I mean, we understand that medical records stay under seal unless they're used in a trial where they're public, but they're not given in discovery outright for us to see, unless, you're in Florida, and sometimes they do give medical records. But that leads me, if medical records are under seal here, right, that leads me back to the breaking and entering that Middlesex said they weren't going to prosecute, and Essex said they weren't going to prosecute because they didn't find PC, probable cause, because there may have been some kind of cop involvement that said that he could go into the house. Yeah. I can't wait to hear which cop. I mean, I'll be filing the civil suit tomorrow to find out which cop gave permission to break and enter, because there is going to be no officer who's going to admit to breaking and entering, to allowing a breaking and entering, unless there's a police report who says, oh, he called and I gave him permission to break and enter. But if it was, he's going to say that Justin lied to him, right? Well, the cop's going to say he lied to him. He told me he had permission to go in. He told me, but that somehow he got there and somebody had changed the locks without his permission. That's why he needed to go in. All right. Well, I know Middlesex said they had confident look, but they said they weren't going to charge him and give him the excess. So Essex said because Middlesex wasn't charging him, they also took a look at. They weren't charging him. You can't make this up. You can't make this up. Okay, you can't make this up. Yeah, medical records. It looks like Justin already has a lot of her medical records, because part of the motion, as I said, it was brilliantly labeled. That was filed yesterday that we talked about last night on the show, was that he got into her medical records and forged authorizations to get her medical records back then. This was last August. Now, and then the computer had been returned to the house, making it look like it had never been taken. Maybe when she got out of the hospital, in case she was looking for her computer, there it was, back to where it should have been in the first place. I mean, you can't make this up. And this doesn't bother the judge. This doesn't bother the judge. Made of questions said Barrow said he heard the call, and Justin said he lived there, and the cop said, well, if you live there, then sure. That's what I said. No cop is ever going to say you can break down the house unless unless you've told them that you have a valid you have a valid access to the house. Yeah, he lived there as in D, not and the problem is he filed an affidavit under oath that he was living with his parents, and I guess it was Stowe, Massachusetts. Classic clip, he says, Linda, EMT board and medical Medicaid as to violations of records. You can file you certainly can file a HIPAA violation, but that's not necessarily going to go help you so quickly right now, okay? Yeah, I mean, that's, the problem is you want to be able to cross-examine him, and the prosecution knows that, Justin, if he gets on the stand, he is going to be dirtied up so much, okay? And his brother, as we reported, and those 2 firefighters, one of which may have been a prior North Andover firefighter. I would suggest that there are they're buddies. Yeah, but the problem is that they may take his certifications and all that, but we need something now, right? We need them now. And if they do all that and he's still not called as a witness, the courts will just say, as we just heard, well, it's irrelevant because he's not a precipient witness. The prosecution, it's irrelevant because he's not he can't testify to anything that happened. And the only thing that matters in this case is what happened up in that bedroom when Kelsey shot Officer Noonan. Okay? That's the only issue. I mean, everything else, quite frankly, everything else, if he loses his job, there's the child support that he can give the child, right? For the child goes down. If he's gone, if he doesn't have a job, so Kelsey's kind of, is kind of like in a bad position here, right? Because then what? She's the sole supporter of the child, but she doesn't have a job. So then who supports the child? And then what are they going to do in probate and family court? Are they going to say, are they going to, I don't know what they're going to say. In any event, who's the victim in all this? Not just Kelsey, but this poor baby. That's who the victim in all this, okay? The other 3 persons who broke into their house, we have sourced Mark Blaine 8438. If you go to our Twitter account, we were sourced with the names of the brother, Brandon, of another Haverhill Fire Department fire person, what do you call it? Fire? It's not fireman, fire person, firefighter, I guess is what we call everybody, right? Them. So it was the Brendan, not Brandon, I apologize. Brendan, the brother, a friend at Haverhill firefighter who may have been a North Andover firefighter. His first name is Hunter. Okay. That was sourced to us. And then the other person was definitely a North Andover, Massachusetts firefighter, but we did not have a name. But that was our source information, and we are very confident in our source information. So yes, so there you go. Okay, that's that was in our Twitter account, and we stand by it. All right. Now, here's the problem with grandparent custody. Kelsey's grandparents, I have no problem with, although the grandparents of Justin are seeking to keep that away, keep them away. But they've had control of this baby. So what does the court say? Well, as a baby, if the other grandparents come to him, as the baby gets older, when do they start recognizing people, right? Well, and maybe the best interest of the baby to stay with Justin's grandparents, even though they may have been or had knowledge of this of complicity. Michel Bryant, by the way, is entering the studio. So I have talked a long time. I have explained everything. Michel Bryant, I had 2 segments. I just want to tell you, one where we took a break when there was that long sidebar, and one just now after we finished court. I think I've been explaining everything pretty well to everybody and answering everyone's questions, but they're really waiting to hear you. You are in the courtroom, so I'm letting you take over, and I will try to.
Okay, and I appreciate your filibuster. Always able to fill in the voids there, partner. New courtroom, yay! New courtroom, and a lovely courtroom. May have been difficult to tell from the one static shot that we were able to provide, but very nice, older courtroom, and held about 40 people, and it was packed. Everybody in their seats. A lot more press than there had been, and I guarantee you a lot more press than there would have been, but for yesterday's dock drop and motion drop by the team Bradel. And so there were, I want to say, a dozen members of the mainstream and streaming press there. So quite the gaggle in the presser as well, which was just finished. I don't know if somebody was streaming that or not, to be honest with you. I don't really
I didn't have time to go look. All I know is that Judge started this morning by saying, I want to establish whether we're going to have the press and the media and what we're going to do about the trial instead of the real stuff, like, right?
What? Anyway, so I'll upload what I have, which was from a kind of triumph the insult dog perspective, as I've done before. So let me just give you my very first encounter as I get to the courthouse. First of all, Scott McGinnis, and I've uploaded our little take. He had just received as they just released the decision from Doolin on the Karen Reed matter. Really, it wasn't the Karen Reed matter, but it's the phones, the Proctor phones. The court said, yeah, give them to her, give them. And it's really the extraction, because I think Proctor lost the phones, but the extraction's going to Karen Reed's team now. So, and all the others might be impacted by that. So that's amazing news. So I get to the courtroom, and it's on the 3rd floor. There's only one courtroom there. I get in the elevator to go up, and who's in the elevator with me?
I don't know.
Hank Brennan.
Are you kidding me?
So me and
Are
Hank.
you kidding me?
No.
Wait,
So-
really? Did you tweet
so-
this? Did I miss
And I'm
something?
like, I did. So I'm like, and this is just a weird, for many reasons, this is just weird. And so I said, oh, hey.
Especially since last night I said that Justin the alien should call Hank Brennan and get some representation.
So I said, you have a matter in the court today? Well, not a trial, actually, just a change of plea. And I said, oh. He said, what about you? I said, well, have you heard about this Kelsey Fitzsimmons case? A little. And I said, well, I think after today, you're probably going to hear quite a bit more. And I just asked, as a spoiler alert, the last question I asked of Tim and counsel and everybody else that was there at the mics, I said, so there was a discussion about getting a special prosecutor. I saw Hank Brennan in the courthouse today. Everybody just kind of cracked up. And Tim said, I would love for him to be the special prosecutor in this case. We're pretty sure that's not happening.
That's wild.
Anyway, so in fact, then I got out of the elevator and I was waiting in the lobby. He went down to the 1st floor, which is where probation and another department is. And the elevator came back up, open on the 1st floor. He was still in the elevator. I said, is this the new job? You're now like some elevator operator? What's the deal? I know I'm not. I just have things on different floors. Okay. So then we go in. I learned that the only matter on the calendar was going to be this matter. And I'm sure you were a bit surprised, as I was, that the court entertained all of these last-minute motions, not just yesterday, but this morning, which was the motion for a change in the bail conditions.
Right.
You must have chatted a lot about that. Were you surprised?
we talked a lot about it. We talked a lot about the judge said, I wanted to help you. That was after he talked about the media and what they were going to do. He said, I want to help you with that. And at the end of this, I will address that. Yeah, I was surprised, but I wish he'd make the goddamn ruling. Excuse me, God. Okay,
Yes,
I'm calling on you because, right, you've got, poor Tim, Judge Naaman's not on the case. But all of a sudden, he can't change because of Rule 58, the bail conditions, but I'm changing them. I think he went and called the assignment judge, by the way, in that break at the end.
You can guarantee that he went back there, got on the horn to somebody, get my ass out of this frying pan, please. And this is all on McCarthy Naaman, all on her, this whole problem. And he did, whoever gave him advice gave him the best advice, which was just reach out to the presiding judge, chief, whatever they call that person that assigned him to this trial, and say, this is your baby for all purposes. Then he can dive into that contradiction with the probation report and whether the conditions of bail overlap with the probate and family court, which is insanity, of course. But if you're in Kelsey Fitzsimmons' position or her attorneys, you're gun shy. You don't know what somebody's going to snatch you up and say, well, look, you violated this part of the order. And so Tim did a smart thing by having the judge place on the record that you're bound by the letter of this order. So none of that crap that Naaman was spewing, including the impression that, Paige, her mom, has to be like her escort everywhere.
Right.
So now they have a little breathing room from that, which is great. And I think that's great. I think the judge, on balance, was good. He seemed to be somewhat in control, personable, not a hard ass. I do think, Gubitosi is a dick. Sorry, he is. That's a legal term. This guy is, why does he think it's so important to pop up and say something about these bail conditions to make it harder on her? I think he's afraid. I think he's just afraid of whomever above him is going to squash him and say, look, that's none of your business. We made the ruling. Your job is to sit there like a good little soldier and object if the court tries to change what we've arranged. I was not impressed with Gubitosi. He is like a virus.
Yeah, but you know what? Can I get your opinion on this? We talked a lot about this. You know, you file motions, as you and I know, for other reasons. And what Tim got out of here is that they're going to try to do a proctor on Justin the alien. They're going to try not to call him as a witness, right? That's exactly where they're heading, you know, and therefore he's not precipient, so you don't need any of this discovery about him to dirty him up, because we're not going to call him. We're trying the case without him.
Yep. And to me, for him to say, well, Your Honor, he's not really a key witness. He's not a key witness? How is he not a key witness? Not only from his presence on the scene, but the reason the cops were present on the scene. Yeah, right. He wasn't in the hallway, the doorless hallway, when the shot was fired. Yes, we get that. But remember, that also impacts Noonan, because now we have what kind of accommodations were given to Noonan that has protected him post-shoot. And the judge took the easy way out on that. I could see it happening by saying, look, that sounds to me like that's an employment records issue. That's a Rule 17, which would be a third-party records request. That's what that is. Get the records from them. The problem is for Tim Bradel is he's asking for the DA's office, the Commonwealth, to give up documents that are self-incriminating, and they are not going to do that. And that's the problem with this kind of discovery rule. Yeah, it puts the affirmative duty on the entity to look beyond just, hey, I opened my desk drawer, I don't see anything, but you have no way to confirm they did it unless you, through independent investigation, find those things yourself. And you can say, well, wait a minute, you told me there wasn't anything. What about this? Aha. And I think we could see some of that. I definitely think we could see some of that.
Yeah, I saw that. And that's why I thought actually the motion, as the way this played out today, I thought the way Tim phrased that motion was brilliant, because it took away the issue of, hey, this, you don't need an affidavit here, Judge. This is not any motion to strike. This is a motion to give you notice that you're on an affirmative duty to look for this stuff under Rule 14. You know, Judge Beverly Canoni's new rule.
Yep, I mean, she did. That's the best thing she ever did was craft, stricter rules under Rule 14. It still always comes down to, enforcement. And is there going to be any enforcement? Let me see. Let me check some of my notes here. Ask me anything that was maybe nagging at you as you're watching.
We had a lot going on. The trial date's still the trial date. This judge is specifically set upon this trial date, right? Why hasn't there been a witness list so far? What's the issue with the witness list?
This I think in part relates to and Tim and I have talked about this, where I'm not going to show you mine till you show me yours, and the prosecution has not complied with providing. Now, their witness list may technically be outside Rule 14 requirements, but there's still a good faith effort. They're the prosecution, and the defense doesn't have to do anything. So if the prosecution gives them a witness list and you look at it as the defense, you go, well, there's nobody on here that scares me, or we need to rebut, or that we need to have a contradictory witness for, then I don't need well, how can you react? How can the defense give a witness list until the prosecution has? So there's been a little gamesmanship there. And I don't trust Gubitosi. He's kind of a Weasley guy, and I think he's just trying to maneuver it away to disadvantage the defense and basically force them to come to court to get the judge involved. Luckily, the judge.
How about this? This is the other question we have. How about this? Essex County decided not to prosecute because they didn't find probable cause after Middlesex County decided not to prosecute. All right, because apparently Justin said that he had the authority to be there, and Kelsey didn't. Well, she's in the hospital being shot for 3 days when she's visited by these two other people we just heard about, somebody from North Andover and a state police officer. Didn't say he couldn't go in the house. What about that? What's that all about?
Yeah, that was Gubitosi putting the best spin he could on it, but Bradel was very quick to correct him. And because there's a recording, and maybe Gubitosi didn't know that, but the recording makes it clear that the alien made it appear that almost like, oh, I lost my keys. I still live there, and I got to get in there. And so the cop wasn't like, sure, go ahead. The cop on the end of that call was like, well, that's your call. If you say you have the right to be in there, we're certainly not going to stop you. So that's
what I said. No cop is going to say they give him the authority to go in if he said that he didn't, if he had moved out.
No, Of course not. And so, the prosecution can try to water down what we see in that video as much as they possibly can. And I understand what they're trying to do. But it isn't a guy walking up, tapping on the front window, waiting, there's no answer, doing some sort of, jimming of the handle. Doggone it, I can't get in. This guy walks up to the porch, lowers his shoulder, and blasts through the door. It speaks for itself. So I don't care what you have to say about.
And then goes and disrupts all the recording equipment and breaks it all.
Yeah, and you'll notice that they got back one of the recorders today. In fact, Steve, Kelsey's dad, had that with him at the little presser. It looks like a DVD player, but it's actually the recording device from the original system.
And what's it supposed to have? It's supposed to be they just got it back, but it doesn't have anything on it, or do we know?
I don't know. I mean, he literally had it in his hand, standing outside the courthouse. So we'll see if that gives them anything or not. One thing that again, Gubitosi said when he talked about the alien going into the house, he said he gathered his belongings and left. Really? Is that what he did? Gathered his belongings and left. Like it was, hey, I left a pair of pants here. Let me grab those. I mean, it's just so disingenuous. Nobody looking at that video comes away with that belief. Nobody.
So how does the judge not have the authority to find a conflict of interest and say you have to get validated, you have to have the ethics board rule on this, or you have to have somebody independent look at this? How did he say? He said, I just don't have the authority to say you have a conflict of interest. What the hell happened there?
Yeah, he really punted on that. And I think it's because Naaman has put him in this, his balls are in a vice. And so, there's no way for him to feel comfortable.
I can't say that. I'm sorry. I apologize. That picture in my mind is.
Yeah. That there's no way for him to act as independently as he probably would, could, and should, because this, she's been described as a ghost, but she's hanging over this proceeding. So again, by Carb going back to the head judge and saying, look, give me the total dispensation here, I think that's going to clear the way. And by the 12th, when they meet next, I think a lot of these issues are going to be resolved and for the good, including the ability for Kelsey to now revisit the probate family court and get into that custody battle.
And when's the trial date? March 27th, or did I get that wrong?
March 23rd. March 23rd. So they're meeting 11 days before that. It's a Wednesday or Thursday to go through these final little things. And hopefully at that point, the judge will have full power.
Do we know what the forensic report was on the guns? Because Tim Bradel withdrew it. He said because he wasn't sure that he had all the reports and the CVs of the gun expert. He thought that related to the officer's guns, not Kelsey's gun. And Gubitosi made a representation that, Kelsey's guns, one of the guns we tested or something to that effect. And then Bradel withdrew it. Do we know what that's about?
Well, it sounded to me like there was a little bit of confusion there, even on Tim's part. And you can see, Courtney is on the front seat behind the bar, and she's very involved in making sure he's got the right bits and pieces. And I think there was some confusion about the 3 guns that were identified by the prosecution. He thought it was the 3 cops. Gubitosi said, no, that includes the gun, the service revolver that Kelsey Fitzsimmons had that day. But the thing is, this is not a whodunit. Yes, they've matched the bullets to the gun that was fired by Noonan. Well, whoop-de-doo. I mean, I don't think that's a big issue in this case. I think Tim was more concerned that he wasn't getting everything because he thought the 3rd gun was her gun. I mean, was the cops, not her gun.
Okay. That's what appeared. But you know what? It's always good to check with Massachusetts because you never know if they're trying to pull a fast one. It appears. Do we know why she was visited by this North Andover police officer or the state police officer who wore the body cam on these 2 separate visits?
Yeah, that's interesting because they played a little coy about that. Even Kelsey did, because the question was, well, was this a personal visit or was it an official visit? But whoever it was, this Detective Dan something, is that right? Is that who that?
Yeah, I didn't get the full name.
I wrote it down. Right? Detective Dan, I think of Forrest Gump. He had the body cam going, and he advised her, "I got a body cam." So
a la Luigi Mangione, who wasn't advised that he was being recorded in Pennsylvania, right?
Yep, and that's true here in Massachusetts. It's a 2-party state. Oh, here's a breaking news bit. I asked the gang at the end, I said, now we know today for the first time that the Commonwealth chose not to prosecute the alien for these alleged crimes. And they went
By
through
the way, I have to stop you. I'm going to stop you
Okay.
because in the middle of this very important hearing where we're trying to hear the judge, you know, and he's very low, and although because of your intervention, we were able to hear Bradel very well, right? He says, Justin, the alien,
I
and
know.
somebody says, well, how do you pronounce his name? And they said Elaine. So I said, Michel Bryant is the ghost over Tim Bradel. He called him the alien.
It's not just me. I said, right on, Judge. Yeah. Yeah. So I've been vindicated. So I asked, I said, Tim, we heard now from the Commonwealth for the first time since you advised them in August of all of these alleged wrongful acts that they decided not to prosecute. Have you reached out yet to federal authorities about any potential bank wire fraud, any of those issues? I'll give you the short answer. You'll hear the longer answer when I upload it. But basically, he said, we're looking into it. So it's an issue. And Martha looked right at me. Martha Coakley was like, you know, in sync with where I was going there. So,
well, I keep saying on the air, like they brought her on for her juice with the federal authorities, with the attorney general. I said, where are they? Because that's why she's there, right? You know, Bradel doesn't need her to try the case, but what he needs is her interconnectivity with the other authorities where this is going. Do we know whether or not Essex looked at this after August, whether or not they had the issue on the computer involvement at all?
Don't know. Don't know. I mean, there's no record of it that I'm aware. It's we don't know what back and forth there was between August, I think it was 25th or 26th, when Bradel sent that email, and today, because it was very clear that today was really the first time that the Commonwealth admitted, you know, we looked at the totality of the circumstances and we, you know, blah, 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 no prosecution. But whether there was a back and forth between them, that's unclear.
Oh, that's interesting. So I
could see Gubitosi. I'm sorry to interrupt. I could see Gubitosi, you know, when he was squirming. You know, you could just tell when he was squirming. And he also thought some things were maybe amusing, you know, in a kind of a holier than thou way. That's one of the benefits he has, as you've suggested, when you're Massachusetts Commonwealth sits a table in front of the defense. You can get away with a smirk and a twitch, and because they can't really see that. I was on the side; I could see everybody. But yeah, I don't like the guy, and I don't think juries are going to like him either.
So tell us in the courtroom, how did Kelsey look when she walked in? How was she dressed? How did she interact? Did she interact with her team? Did she interact when the judge said anything? Talk to us about Kelsey.
Yeah, she was great. You know, we were kept outside in the ante room, the foyer area there, until about 2:15, and then the bailiffs let us go in and get set up a few minutes ahead of time. But I actually had the chance to interact with her just briefly, and you know, she was great. She's lovely. She'd rather be anywhere else, obviously, but she was talking a lot with her family. Tim Bradel showed up probably. He always comes late. We always end up starting late when Tim's involved. So he gets there just before we go into the courtroom, and so they had he pulled her aside and they had their confab. But yeah, she looked to me in that setting much more calm and relaxed than in the last couple of times that I've seen her. You know, maybe because, you know, when all this information came out yesterday, it had to make her feel better. I was talking to Steve, her dad. I said, how long, you know, have you guys been sitting on this? And it had to be just crazy to feel like, you know, just wait till we can tell the whole story. So I think there was a lot of relief on her part and the family's part that now the bigger story is out there.
Wow. Anything that I haven't asked you that you want to talk about, because we've been talking a lot here. I know you know about all sorts of things. I kept all the notes about everything. Anything the judge you thought should have ruled on and didn't?
You know, I think he actually went further than he might have. I was surprised when especially when he denied the Noonan related stuff. He just denied it out of hand. I think that's going to be a big issue, because hard to argue that Noonan's not a big witness, right?
Right.
And now, whether it's through Rule 17 or a combination of Rule 14 or Rule 17, if Bradel gets any of the materials that we expect are out there, and you know there's got to be this back and forth, like, don't worry about it, dude. You know, we went to his house. He didn't call in sick. He's high on Flexeril, which is kind of a weird drug to be high on. You're more low on
relaxant, right?
You're like out. And then they just give him a pass. And even though he's characterized under the collective bargaining agreement as somebody that's impaired and they're not supposed to work or get certain duties, he got those things. So why was he getting those things? Well, because we want to be chummy with him so he'll perform well during this case against Kelsey Fitzsimmons. I think those documents are going to be fascinating when they come out. It was unfortunate that the judge wouldn't help with that.
Yeah, that is unfortunate. So that leads me to think about this. Did they take drug samples, blood from him? He's involved, an officer involved shooting. And I don't remember, maybe our chat remembers.
I sure don't remember taking anything.
Now that we know that he didn't make it one time because of Flexerol, now that we know that, did they take drug samples from him the night of the shooting to see whether he was, shall we say, under the influence or had drugs in his system?
Yeah, you would think routinely they would, any officer involved shooting. I would think that's standard procedure. During that sidebar, this circles back to the decision by the Commonwealth not to prosecute, because that's when the judge called the sidebar as they were getting into that. I was watching, and they're all very animated. I do appreciate that he said, Miss Fitzsimmons, you want to come up as well? He made a point of inviting her into the mix.
And did she come?
She did, and she was there. And so I don't know what was being shown at that time to tilt away from the courtroom.
Well, we just saw, you saw the side, they were up there, but it was such a far shot that you couldn't see who was moving and who was talking or anything like that.
I think Gubitosi was not happy. I'll put it that way. That I think the judge was pressing upon him the importance of at least having a position on whether or not you had planned to investigate the alien or charge the alien. Something. Got to be something on paper somewhere. Somebody had to make that decision, right? And so there was some sort of agreement made, and I asked about it at the presser. Not sure I got any more detail from Tim Bradel at that point, but there was some admission, it seemed to me, that they did give him a pass. And remember, that's important because that's what the motion was for. What special dispensation were you given? What do they call it? Rewards, or I can't remember the phrase.
There was three, and I'll tell you.
Yeah.
Hold on a second. There were promises, rewards, or inducements.
Yeah. So you could very easily say, giving this guy a pass by not charging him is a pretty good reward.
Right.
And so there was an admission. It sounded to me like, in very loose terms, that the Commonwealth finally, kicking and screaming, acknowledged that may be true. And to your point, let's not call him if you're the Commonwealth, right?
That's what they're going to not do. They're trying not to call him. And I think they can try. I think they can try this case without calling him.
Oh, I agree. I think you're right, because he was not, I mean, he's instrumental in terms of being there, but you don't need him. Look what they did to Karen Reed too. All those folks that were involved with it were never called. Yeah. So if you're on the defense, if you're Tim Bradel, do you call him?
I don't know, because does he become a witness that you can cross-examine? Is he an adverse witness? And so he may not show it. He may get up there and said, I thought that she was going to harm the baby because she'd been, on XYZ. I don't know if you call him. I don't know if you call him. I don't know if you can call him. Yeah.
Maybe depends on what you learn, what more you learn between now and then, now that you've opened this can of worms. It was interesting. I thought that Gubitosi said, if he takes the stand, meaning the alien, I'll grant him protection from Fifth Amendment waivers. That he said that almost as a throwaway.
He said that because that's what the thing I said, that I filed motion recently in a case that said to the judge, look, judge, we're just putting on notice that depending on how this witness testifies, you may have to give this witness the Fifth Amendment rights on the stand. We never reached that point in the trial, but I filed a motion and put it all on notice there, so even the witness was on notice that there's an issue with regard to the Fifth Amendment. So
So
now they're saying they're going to give him immunity no matter what.
Well, it just made it sound like if he's called, if that becomes an issue, I will protect him on that. That was
wow.
Yeah, it was in open court, but it was just sort of as a throwaway part of the conversation.
Wow, we didn't hear. I missed that. That's a big throwaway. So you're up here testifying under the grant of immunity, then you get to go into all this. Oh my God.
Yeah.
And he can't give him immunity from the federal crimes. And immunity only applies to the county of which you're given the immunity in Massachusetts, right? So it only applies to the county, and it doesn't apply to federal crimes. So if I'm his attorney, I'm telling him, I'm not taking him. I can't answer that. It's question by question.
Yeah, well, we'll see. I think that would be a head turner. You know, in every trial, there's a couple of folks that you see and hear so much about that when they walk in the room, you're
Yeah,
watching
because then
their
you're going to have
every
to get,
move.
you're going to have to get Middlesex to give him immunity. You're going to have to get Essex to give him immunity, and the feds are never going to give him immunity.
Yeah. Yep.
Oh,
Let me
holy
think.
moly.
I think there's anything that I missed. Any color. A lot of the usual suspects
How about
were
the
here.
presser? Yeah, how about the presser? Anything that you didn't talk about with regard to, you're going to upload
I'm
your
gonna upload it as
questions,
soon as I get landed.
and then everybody, and that'll be about 3 hours from now when your wife is not going to speak to you because you're missing her birthday by being with us.
Whoopsie.
No, I know that. I know she's not. I know you
that's
did
well,
wonderful things for her before her birth tonight.
It's what does she say? It's not,
Celebrate.
it's not her first birthday. So, and it's not her last. And when you've been together 20, almost 24 years, it's like, I get a pass. Anyway.
You get. Oh, I can't let my husband know that you get a pass.
Yeah, you know.
Pass.
Yeah. Let me think if there's anything
I'm
else about
Italian. I don't give a pass.
Oh, I will say the bailiffs were very accommodating. I think they overdid it. There were 4 of them in the courtroom.
Wow.
And the head guy, who's a super nice guy, was a giant. They were all very friendly. The court personnel were great. I liked the environment here. It felt, it didn't feel like there was, this nervous energy, like I felt so often in Dedham. So I think it's going to be a good place to try the case. They reinforced that they assume 3 days, give or take.
That's it.
Yeah. So.
Well, not if Justin gets on the stand. You know.
Oh, I know, and that could expand or contract depending on what the defense decides to do. Yeah. Oh, one complaint. It's a very old building, but I'm upstairs on the 3rd floor. And I said, I had time. I said, what is there a restroom? Oh yeah, there's only one, and it's on the 1st floor.
Oh dear. Oh dear.
So keep that in mind if you pop by for a visit. Beeline to the 1st floor bathroom, straight down the hall to your left, and then you're good. But if you if you don't make that commitment early, you'd be waiting in line.
Oh my goodness gracious! Especially if you have the issue of where the press is going to be, and the judge wants to deal with the press and all that kind of stuff.
I mean, he was certainly fine with it today. Everybody was in the jury box. Jess was there, and Charles, and Mike Crawford. I'm trying to think of who else was. Let me show you this. Let me just spin around, just because it's such a beautiful little area here. I love being by a park like this.
Wow!
Wide open park.
Great for our Starlink.
Great for Starlink. So over here, you can't really see it too well, but the distance, the building in the distance there, it's all brick. That is the actual courthouse. So anyway, so yeah, I saw this park and I went, oh, thank you. It's so much better.
You.
And now Elon has tweaked Starlink, as you know.
Mm-hmm.
It used to be much more proactive, where you had to take your phone and pirouette in the street like an idiot so you found the right signal. Now it apparently does it itself. And then it will just advise you if you need to turn it differently than you have it. Because they have so many satellites up there. It's like 8,000 satellites up there now.
Yeah.
So I haven't been monitoring this that closely, but if we haven't had glitches and stuff, that's just, I threw it on the roof and boom, that was it.
The mobile studio. Yeah, we are. I went and bought Mobile Studio 2 today, by the way, just so you know.
That's right. I can't wait to see that in action.
Yeah, I can't. Neither can I.
All right.
Anyhow, yeah. So you're gonna, when you upload the presser and what your questions, will that be on our YouTube page? So people should pay attention
I'll just
to that.
upload it as a video. I think it's 15 minutes long. It was pretty long. A lot of people.
All right. And so that'll be on our YouTube page. If I'm around, I will try to also notify you on X. But if you really want to be notified when Michael uploads it, please go to our YouTube page and hit subscribe, share, like, and notify. And of course, hype, since we've been on the air since how long with you all now? About over 3.5 almost 3.5 hours. About 3.5 hours.
That's yeoman's work.
Yeah, well, we've got a yeoman's group. People have been with us all day, and they've asked fabulous questions, and they were all waiting here, and they stayed with me because they definitely wanted your input because you were in court, and they thanked you for being in court and for driving these 6 hours today just to do this.
It was I was giving Tim Bradle a hard time. He said, "Did Courtney get you what you needed?" Because some documents were not attached.
Not the bail motion. I had to go look for that. And by the way, I did put on the last page of it to go through it with it during the break. Here's the last page of what Bradle was looking for, just so you know.
Oh, so that's a different issue. I went to, when I got the stuff from the motion from yesterday, I sent him a note, said, "Hey, no, I got everything. Courtney was great." And I said, "Now I'm actually going to make it because Courtney threatened me." So I wasn't really planning to go. And then when we talked more and more about it, boom, I came. Today, I'm there in court. I go to Courtney and I said, something was filed today, because I was busy, and she emailed it, but I had no time. So she handed me her copy, and I was able to look at the bail condition motion. And about 2 minutes into the hearing, the judge started asking about and so she's like, hey. I had to give her back the copy that she had loaned me.
That's hysterical. You know, I put up the last page because we didn't have time and reason to go through the first pages right now, because it was just
the
what he
key
was
was
asking
those
for.
elements that
Right.
And you know, he had a few, as I've said in the past, in the TV business, we call them producers' turds, things that you ask for, but you probably could live without.
Yeah.
So there were a few of those things thrown in there. He really wanted the shortened time for notice and no chaperone, you know.
No chaperone.
So
And
he got those. Now she can drive 2 hour notice.
This is a good question, and we talked a little bit about what did the judge say about seeing the baby, because Tim said that look, it was the family court basically said they couldn't do anything because Justice Judge Naiman, McCarthy Naiman, had put a condition of her bail that she couldn't see the baby, and if she's not in the case and you're not in the case, does that go back to the whole issue of this judge that he has to be given control by the assignment judge?
Yep, and that's what they expect to happen between now and the 12th. The judge is it's like an Italian name or something, Gioschi or something.
Yeah,
he's the guy that put Karp on this case for the trial, but Karp wants him to make it very formal that this is your baby for all purposes. Then he can go back in and change that condition so that it is. I mean, why do you have a visitation issue as part of a bail condition? It's already covered by the Family and Probate Court. There's already a temporary restraining order in place there.
Right.
And that should control. So that's what is likely to happen. They're gonna give him the power. Karp will then remove that. Oh my God.
Oh, coming to get you.
Yeah. Karp will then remove that, and all the deference then will be to the Family and Probate Court, and she should be able to move forward.
Right. And then Scott McGinnis, hi Scott, got to hang out with Michael someday. Hi Linda. Hi Scott, thank you for and Scott's such a great supporter of all of these people have been wrongly and I said Karen Reed and Kelsey, and then of course Scott is also such a big supporter in supporting that Sandra Birchmore get justice also. So thank you.
And
Scott.
as I mentioned earlier, he was at the Karen Reed related hearing. It was really the Miles case, but Karen Reed, the benefactor, we know now from getting the Proctor phone info. So yeah, I'm gonna hit the road. But first, I told Hank Brennan I'd meet him for a drink. So hey, I'm gonna go meet a Hank. Okay, so hey, have a great weekend. Thanks again, and
have a good trip to. I know it's not a fun trip to Florida. I know you're gonna be busy with us. That's not.
I
might
not
happy.
Be an impromptu where in the world, but we'll see.
Well, you'll be in Florida, so I just gave it away. So
well, Florida's a big state.
Yeah.
Okay, guys, have a great evening, great weekend.
Thanks, Michael. Bye everyone.
Baden flames, they charge